Mention your lordship. I don't mention your lordship. 9 deed of bills, your lordship. We are the respondents. We were Yes, sir.
I don't know. Mention me. I VC.
Should we file a compliance affidavit? Lordship. That's a period of 8 weeks.
8 weeks.
8 weeks.
So 8 weeks are over. Completed from 15.5.
Lordship. You've already filed a compliance.
Receipt, Lordship.
Yes, your lordship. Both. Yes.
Yes, Lordship. Have a glance, Lordship, in page 6.
Compliance is there.
Yes, your
Yes,
lordship.
Lordship.
The recent order it has been
You given
rejected, your lordship.
rejected.
No, Lordship, but rejected, Lordship, but have a glance, Lordship, in paragraph 5.
How are you particularly not that you want to how that order is escape from my notice they can't escape.
No, your lordship, a recent order has been.
So application is made 20 years from this.
Yes, your lordship. And that, your lordship, after a delay of 7 years after attending majority also.
Otherwise also 30.
Otherwise also.
Yes, Lordship.
Okay.
Lordship, at the beginning, Lordship, they have kept the file pending for a long, and after Lordship's order, they have rejected the claim, Lordship.
Any standard for law that a year for this the government report is not supposed to be medical examination of compliance. If compliance is substantial compliance, that and then you get the thing it will be liberty to challenge. The order to violation being complained of having been complied with, why the continuance order dated
2/6/2025, your lordship.
26.
26. Sorry, your lordship. 2/6/2026. 26.
Now, the content proceedings are liable to be dropped. Either about or they are almost every either to the claimant to assail the state order gets made in accordance with law. And for that purpose, all contentions of the party are kept.
Also, the compliance affidavit has been filed, your lordship. Here, after 30 years of death of his father, he has applied, and after a delay of about 14 years after attaining the age of majority, your lordship.
Lordship, she permitted to have a glance, Lordship, in page 6, paragraph 3. Lordship, Lordship, the petitioner's case is one. Here he has copied another petitioner's case. Lordship, have a glance in para 3.
That happened in the year 12/7/1983, Your Lordship.
12/7/1983.
Yes, Your Lordship.
You applied for notation appointment on which date?
19/3/2013, Your Lordship. After Son, Your Lordship.
Son. When he attained the majority?
He attained majority on 5/9/1996.
Majority how many years?
14 years, Your Lordship.
From attaining the
He
what period the candidate should stay in from Contempt?
within a year, Your Lordship. Within a year.
So that earlier limitation is written from the date of these attaining majority.
Yes, Your Lordship.
He attained majority on 5/9/1996.
Beyond 3 years, Your Lordship. I'm sorry, 3 years.
3 years. See,
9/7. Rule 9/7.
it is not true.
His lordship true, but here is deviation, my lord. In page 6, paragraph 3, my lord. Here is the petitioner is Prasan Chatpati, and he has copied another petitioner's case. So maybe your lordship kindly seen. I have received this copy, lordship. I have received this copy, lordship.
In that order.
Yes, Your Lordship. I'm here.
I will not allow the officers to do what play at all. Like it's something from some ground. Otherwise things cannot happen. Both others to be interesting. And I mean, never allow to have. The order is supposed to be complex.
This content matter value, the lordship's order has not been complied with.
Okay. This is supposed to be.
No, not
Science.
public.
I don't know, mention me lot one. Sorry, me lot to disturb. I am VC me lot. I am VC me lot. Ana. Lot one read your appeal me lot. File in January 25 me lot. Till today, it could not list a death case. I am trying to get the compensation of death of my mother me lot, who died in a fire accident.
Give number to contact.
My lord, you read your appeal 8004. 8004 of 2025, 2025. May from Monday, me lord. I am 3 years, 4 years I am waiting from my lord's order, me lord. Offline.
Providence Imperial Tribunal has directed for payment of certain financial benefits to the petitioner. That order we have challenged, my lord. Last occasion, the lordship directed to produce the copy of the order of the previous writ application. I'm
Out.
You are producing the copy now.
now I'm producing the copy.
That has gone in favor of the opposite party. That is implemented. This
Order is implemented.
Yes,
That order has been complied with. But here it is another case, my lord, in which he has been directed for payment of certain financial upgradations.
there are
That, my lord, we have challenged on the ground, on various grounds, my lord.
not opted for the cadre. Not
My lord,
opted. Not opted for the SS cadre. He did not opt. There was an
Well,
option exercise. I did not opt. That is the final
It requires consideration.
item page 8.
Order
8, my lord.
Order 5/5/2026, having been complied with, they produce copy of the judgment of this court referred to in the order that was impugned before the Central Administrative Tribunal, Cuttack, pushed this matter after 3 weeks.
This has been implemented. Is a part of page 68. Page 68, my lord.
Interim order to continue till it's been known.
Para 8, my lord, can kindly drop. Para 8, my lord, they have said that he has not opted. Para 8 of the
Let
judgment.
us. Yes.
Order number 2, WPC 14873 of 2026.
May I please, Your Lordship? This repetition filed against the.
My lord, may I be pardoned? Since he's 68, 70 years old man, so I have a particular date. Only was a single day.
Posted to the last week of July.
Against the order of
Make use of the mic.
Lord, against the order of the Lord Central Administrative Tribunal, Lord Tribunal, Lord, dropped my contempt proceeding going beyond the orders of the original court.
What was the order?
Our order is at Lord, page 74.
17.
4. Relevant is at page 81. Last page 81. Your Lordship, may kindly see last.
No, sir, the applicant was denied promotion. Obviously, it's geometrically false plan. And consequently, he directed the order. So there is no other impediment.
Yes, sir.
The orders, court orders are if, but dangerous words. Once to be promoted to the post of Indian Forest Service will be from the date when the juniors were promoted to IIT.
Exactly.
The order is specific.
Kindly turn to page 29.
20,
29.
20.
Mila.
What the authorities say?
But this is the order. This order, 6th April 2018. Your Lordship, may kindly see first select list 2008A.
No, where is the compliance order according to the
But that compliance order, your Lordship, may kindly see. Here, my junior means I must be promoted from the date that
juniors were promoted.
Rasmiranjan Naik. Here the difficulty is Rasmiranjan Naik, I was recommended in 2008. Rasmiranjan Naik was my junior. Now,
Why can't you hear the judge? We are hearing your argument. You have to hear our arguments also. Where is the compliance order?
Yes, that compliance order is at page 127.
Now promotion is given.
Yes,
but retrospectivity is not given.
Not retrospective. 2018 to 2017, no promotion was given so far as Odisha cadre is concerned because there was an internal dispute. Then for the first time in 2018, they have considered the promotion from 2018 to 2014 for 6 years, and they have recommended my name. Your Lordship, may kindly see page 29 in 2008 from 2008. No, I am not saying that also. The Learned Tribunal, already that issue was before the Learned Tribunal. Learned Tribunal, while disposing of the way, this document was there, and they have said that he will be promoted from the date when the junior was promoted. My junior is Rasmiranjan Naik.
You have said that, no?
Yes.
Mr. Who appears for Mr. Paddy, you want to say notice?
Yes.
What he says is Rasmiranjan Naik's promotion is not starting 5 months. Where is that reflection in the order? How can the tribunal say that there is compliance of the order blind foldedly? Can it be said that way? Tribunal is there to do justice more than what the high courts will do. That is the purpose for which tribunal has been established, going by apex court decision in SP Sampath Kumar versus Union of India, 87 Supreme Court, little modified in L. Chandra Kumar versus Union of India, 97 Supreme Court.
what the tribunal is doing.
Raghumar is a landmark judgment.
Landmark judge.
Yes.
But where is that landmark element in this judgment? Impute
I'll
order.
go through only my because I am not reading this. I am not.
You take notice. Yes.
But only in this Lakshmi see the cost item. They are impeded by name to the authorities. Lakshmi see the cost item.
Now,
If you notice will go on the by way of name, if they will issue the notice in the name of any official, we don't have a lordship as a
the denial of relief to him is not on that,
He is
Denial of relief in contempt jurisdiction is not on the ground. Now you are pleading.
also, my
before-
lord, may guide me this. I am pushing this.
Let us-
If
you file your
legal
objection.
capacity, they have filed the writ, then writ is also not maintainable.
Why?
Because by independent capacity, private parties file the writ. Against private party, they are filed the writ.
No. Not like
Official
that.
capacity, they are not filing it.
Question is not that. You mean to say, then how he should proceed? In contempt proceedings, you can't maintain official capacity. And if he suffers an order wrongly in the contempt jurisdiction, he cannot challenge it in the petition. This is double-edged sword.
What I am submitting my.
No, you file objections. It's not like that.
Yes, yes.
Not like that.
Good, fine.
Issue emergent notice. First of Mr. Pagi, Governor TSG, is requested to accept notice about. You appear for private parties?
No, that's why I am.
Issue emergent. Union of India. That's Union of India. Not here.
Union is not a party. That's why I am telling.
All are
If they make a Union of India along with this, they have to.
No, question is whether it was the Union of India was a party before the tribunal. It was not.
No. So you are not complete.
So let them go. Let
But
them
we are all officers of the state. Huh?
Yes, ma'am.
But Union of India is a party before the UE. In UE, the Union is a party.
No more.
You implead Union of India. We are directing you. Impleed Union of India.
That is the
Otherwise,
surprise
earlier
problem.
it is
Yes,
not
ma'am.
in
Yes,
impleading.
That's why I want to.
Yes, ma'am. Yes, ma'am.
In the fitness of things, we are of the considered opinion that the Union of India be arrayed as OP number 5, is to the petition for complete and effective adjudication of the list brought before the High Court. First one, the petitioner is directed to array accordingly. Now itself. First off, issue notice to OPs 1 to 4. Over that notice. First off, Mr. Pari, Governor DST, personally present before the court on request to accept notice for newly added OP number 5, the Union of India. First off, matter lies in a narrow compass. Therefore, posting immediately after service.
Item 3, WPC 16782 of 2026.
The petitioner challenges this cell notice as well as cell deed, my lord. Annexure
Sale notice and
cell deed also was executed in favor of the purchaser. E-auction purchase. It is a study loan of 2010. When I could not repay the loan dues, 13 for notice was issued. I filed a writ application before this honorable. This honorable directed me to file a OTS application along with rupees 3,50,000 before the ban. I deposited that amount, but not within 6 weeks, within 2 months, with a delay, along with my OTS application. They have not considered.
why they should? When the court has prescribed a period, can they consider it if offer is made after
That is my fault. Subsequently, I filed a contempt application. In contempt application was disposed of, directing both the parties agreed to pay 13 lakhs. It was settled at 13 lakhs. I deposited rupees 5 lakhs only.
Where is that order? You have not deposited entire amount again.
It pays 57.
No, again you have not complied with the order fully.
I deposited rupees 5 lakhs.
Last year.
No, my
If
friend.
you do not
No.
want to answer,
No,
reframe the question.
No, I am not.
It will be only cross-examination
No,
by the court.
13 lakhs I am not.
Counsel. That
13 lakhs I am not paid. 13 lakhs I am not deposited. I am only deposited 5 lakhs.
Well, therefore, there is a non-compliance of the order.
Not non-compliant. Thereafter, they filed the original application before the tribunal for issue of certificate, merit sale certificate, and subsequently e-auction has been taken place. Twice the auction failed. Third time the auction taken place to purchaser purchase the property merit. And what happened? I am in till possession.
What to do? Your position.
And in the meanwhile, I have also filed a essay before the tribunal. The essay is pending.
Proceed.
So may I pray, I'll Lordship may direct the DRT to dispose of the essay within a stipulated period, and till at least for 4 weeks I may be because it's study loan, my the study
Makes no
loan.
sense. That argument is superfluous because the list having been adjudged, orders have been. You want to say something? The order has to be. The court gave lot of leniency to the borrower.
Since 2000,
This borrower appears to be not bona fide at all.
since 2024, the auction has been taken place, but I am in possession.
What to do? Give possession. You give possession. That's the reason auction is done now.
Auction has been done, but they are proceeding with the OA also.
That's all. We direct you now to give the possession.
Even after auction, my lord, they proceeded with the OA.
See, where is the
All forum should be adjusted.
But then taking money, public money, playing with the blender.
I am not played. I am not
That's
played
what.
because
Twice you were before this court. What is it called?
yes, because my son has studied.
We do not know how many sons you have, why you begot all those children, where they are studying. You are the borrower. The duty of the borrower is
That is a defaulter.
to pay first.
He is a
Repay.
defaulter. Admittedly, is a defaulter.
Therefore, we used the word play. We did
Then
not
the
say
Lordship may
misuse
direct
play.
that essay to dispose of within a stipulated period before the time.
We have objection for
If they have filed objection.
I am appearing for the
this play.
no one. I am appearing for the opposite party number 1 to 3.
1 to 3.
Petitioner is the borrower. Apparently, he is a defaulter. First, coercive proceeding resulted into auctioning of the property. First, he was before this court twice earlier. One in WP number 72 and another in contempt context number 7.
Contempt number 1802 of 2018.
Some relief was accorded to him initially. And those conditions having not been complied with, he could not draw bills from the orders. Since the lender stuck to the letter of the orders. First. Now, learned counsel appearing for the petitioner having given us the textual prayer very firmly submits that justice should be done to his client if best direction is issued to the DRT to hear and dispose of
Essay number
the
81.
pending essay number
81 of 2024.
explanation. First, he also seeks some reprieve till such disposal takes place. First one. Next one. Learned panel counsel appearing for the lender bank opposes the petition by filing counter. First one. Since main prayer is not pressed into service, we need not undertake a deeper examination of the said counter. More particularly when the prayer now made is innocuous and consistent with right to speedy justice recognized by the apex court in a catalog of decisions. First time, in the above circumstances, the DRT is requesting to hear and dispose of essay number 21 of 2024 and a warful. First time, discretion lies with the DRT to consider request of the petitioner for the reprieve if grounds do exist.
Public.
Next.
I don't know. 169, please, Lordship.
Permitted to withdraw.
You want to withdraw?
Lordship.
Not happy with the court?
No, sir. As per instruction of the petitioner.
Counsel for the petitioner makes a prayer for leave to withdraw the petition. Person. Leave having been accorded, petition is disposed of as having been withdrawn in terms of memo dated 23/6/2026, which reads as
Item 5.
Item 5, on behalf of Mr. Sahu, kindly pass over me, Lord. Due to breakdown of his vehicle,
fine.
over telephone, he's.
What is this matter? You want to
I have no power.
pass on?
Item 6. Document 183, High Court of Orissa 26.
Since I had undertaken to
Yes, Mr.
put before your lordship the medical reports,
It was about cancer.
the other of my,
Just refresh our memory by a few words.
the petitioner has been served with the notice at Annexure 8. And I had pleaded before your lordship that I would be depositing 10% immediately. And if your lordship permits me, I'll repay everything as per your lordship's order. And I had pleaded before your lordship as regards cancer. In that bunch of documents, I have dug, with your lordship's permission, I have dogged one particular page to the end, towards the end. That happens to be the another of my cancer treatment, which was detected in 12. And at the first page itself, your lordship finds that the petitioner's wife was admitted to the hospital on in March 2026.
So,
And therein also there's a finding of breast cancer and the cardiac and other allied problems. And
no, what is the stage of the cancer? See, cancer is not as dangerous as it used to be earlier. What is the stage of the cancer?
No, stage of the cancer, here in that first page your lordship sees, they have stated at the end, course and treatment given.
Where is the diagnosis? What is that stage of the cancer? Which stage?
That had been operated and she is now
All right. Cancer free.
but immobile. So there's the age factor and allied problems, immobile. And the angiogram report also is,
No, this is of which year, and the report says stable.
well, it's stable, but unable to move, confined to bed, 74 years. The petitioner happens to be 78 and
No, 61 years as on 5/4/12.
no,
You are right.
yes. As on date of filing of the writ petition, they are 74 and 78.
Huh. But the cancer has not come in the way of activities.
No, but this allied
Age
problems,
has come.
age has come and this cardiac problem of late.
Huh. So what you want us to do here?
With the whole thing to your lordship's concerns, I had pleaded yesterday that this was the reasons why the funds were diverted. I was a diligent payer, my lords. But
No, this happened in 2012.
12.
We are in 2026. No, that the lady is absolutely fine for 14 years.
my lords,
Why you are not paid that money after the operation?
no, in 2025 I have paid. Not that I have not paid, but thereafter.
How much you have paid? How much is payable? How much you have paid?
Now it's 2 crores
2 crore 13
months.
2.3.
Months.
So this cancer has not come in the way of your making payment at all. It could not have come in the way. That has nothing to do.
To that,
Where is the causal connection? Mr. Pattanai, there is a famous book on this. The Causation in the Law by H.L.A. Hart and Professor Tony Hon'Ble. A great work where they have treated the decisions of the global courts, how cause and effect are treated, how cause and condition are treated. Where is the causal connection? With your client's wife suffering cancer and you are being not able to pay.
No, in fact, what your lordship says, I bow down to that. But question is, since there's intermittent problems,
No.
I mean, only I have defaulted in 25/5/2025. Till then,
Completed. Your client has, of course, you have to, because they have given the instruction.
my lords,
We are not finding fault with you as a
my
counsel.
lords.
But they're posing that Adam and Eve, my great grandfather, the ancestor, had eaten apple. And before eating, it fell down on their heads. They were injured. Therefore, I could not repay that loan. That way it is. Cancer happened in 2012. April 2012 was the discharge summary.
My lords,
And one particular organ is removed.
my lords.
Since then, she is very happy.
No,
Well and happy.
to that, your lordship, I would just like to bring in that I paid till 25/5/2025 diligently. Not that I have not paid. And
How much you have paid?
Which one is your statement?
my lords, your lordship may kindly come to page, my date chart at B in the writ petition. And in the meantime, my security deposits have been liquidated. That I have
No.
covered in the writ petition also.
Where have you mentioned that you have deposited and how much amount you have?
My lords,
The loan accounts were classified in NPA, demand notice was issued. Where have you mentioned?
Only cock and bull story.
No, you have not seen your B chart, date chart.
no, in the writ petition I have pleaded.
When you counted it,
When did you?
nowhere even.
Paying for the bank.
Page
Not
6.
for the bank. How much money is due?
Page
The outstanding is now 2 crore 54 lakhs.
2.54.
2.5.
Huh.
Plus the order which he challenges it's the physical possession order, which was passed on 18/5/2026.
14 order.
14 order, Malas. So, the remedy is DRT.
Go before the DRT.
My lords, to your lordship's query, at paragraph 6, page 6.
No, that you speak about your fixed deposit that you are getting. Where have you paid? Nothing has been paid.
The Lordship should see page 27, annexure 4. We had given him 4 notices to regularize the account. And paragraph 2. So the objection which he had given post 13.2. So we had considered that.
Even in annexure 7,
Mr. Patnaik,
my lords,
in your representation,
my lords.
where have you pleaded cancer as a ground for not making the payment? You can't improve your petition by taking up a plea that was not there before that was not pleaded before the bank at all.
My lords, kindly turn to annexure 6, wherein my OTS request,
Proteus request.
page 30 of the writ petition. Your lordship may kindly come down to the lines below,
Nine. Why it is
4th line from
hospitalized?
below.
Not
Since my wife has been hospitalized due to
Oh.
Where have you mentioned the word cancer?
Yes, my lords, I have mentioned. Since my wife has been hospitalized due to suffering from cancer, I could not pay bank dues. Now I am ready to settle the loan under OTS. I am ready to pay 10% of the outstanding dues.
No, it's the most dangerous liars are those who lie on the verge of truth. Really.
That I do. I haven't.
When cancer happened, what was the stage of cancer? When she was discharged, nothing is stated.
No, whatever.
You are only saying cancer because that will impress the banker, maybe the court also.
No.
But that is not the
No,
case.
in fact, my endeavor is not to mislead the honorable court.
You go before the DRT.
But the documents
Let him
as
go
this-
before the DRT. Let him approach the DRT within 15 days. Till then, you keep your hands off. All right. If you press into service doctrine of alternate remedy, then you cannot do something that will come in his way of seeking that remedy.
Let's act. We have 1 month of, because there is an order of possession, right? It says that we have to report compliance within 3 months. Once it was passed on 18th of May. Now
18th of May.
18th of May.
So
now it's already a month which has passed and there is a
for
support.
15 days you don't do anything. You go before the DRT.
The Lordship may record my objections.
Challenge is to the coercive proceedings, essentially culminating into an order of Section 14 of the Certificate of 2002. The borrower, petitioner borrower having not scrupulously repaid the loans outstanding. Loan. First one. Learned counsel Mr. Patnaik draws our attention to a part of the pleadings relating to the disease or the cancer suffered by the client's spouse, and that was in the year 2012. Therefore, that's another part which is to exercise our jurisdictions, animated with human value as such. First, next one. Learned counsel also submits that his client is ready and willing to make the pre-deposit of 10%, and therefore entry should be granted by the writ court. First time. This is opposed by the learned panel counsel appearing for the lender bank, who highlights the number of opportunities given to the petitioner to scrupulously pay the outstanding installment, which he did not. First one, he tells us that this court should not grant interference in matters like this, inasmuch as the petitioner has got an alternate and more efficacious remedy under Section 17 of the Act. First one, no extraordinary circumstances are demonstrated before us to take a deviant way of interfering. First, next, about circumstances. The petitioner is the petition is disposed of, relegating the petitioner to the alternate remedy as indicated above by the panel counsel hearing for the bank. To facilitate the invocation of that remedy, the parties are requested to lay their hands off for the coercive proceedings for a period of 2 weeks. First, all contentions are kept open, and nothing stated herein above shall be construed by the DRT while considering either main matter or the request for reprieve.
My lords, before your lordships conclude, there's in Annexure 7 where my OTS was rejected, there's a line, you are advised to offer your proposal for settlement of dues through compromise acceptable to bank. If your lordships permit that, then
all contentions are kept open.
Yes, and if he doesn't file, then I will be given the liberty to proceed.
That goes without saying.
That goes observed because there is an order of the court.
Limited reprieve granted now is not invoked, it is open to the lender bank to precipitate the matter in the way known to law.
There's one more thing, this interim order may not be construed as flowing through the entire proceeding.
Yeah, we have said it. We have said. Because they should not think that High Court itself has granted interim order.
So that it will
we
continue
also
through the DRT.
You're right, we have made it clear. Yes.
Item 7, this is 18689 of 2026.
May I please, Your Lordship?
Yes.
The petitioner number 1 is the borrower and petitioner 2 is the co-borrower, Your Lordship. They have availed the 2 loans. First loan, Your Lordship, 2015, January 2015 for 8 lakhs for the construction of residential house, Your Lordship. Then, Your Lordship, one top-up loan out of that, Your Lordship, on December 25, 15, Your Lordship, that is amounting 4,75,000. The total loan is 12,75,000 available, Your Lordship.
That is 4,75,000.
Yes, Your Lordship, second loan.
So total it will be
12,75,000 loan.
right. How much you have repaid?
We have paid till today, Lordship, 8 lakhs.
You paid 8 lakhs already?
8,31,120, Lordship. We have paid. till date. And the loan accounts NPA declare on 7/8/19 Your Lordship. During COVID started Your Lordship, we lost job, then unable to pay, for which the NPA, the accounts declared NPA Your Lordship.
NPA was declared before
August.
it was notified.
7/8/19.
Came to Wuhan in China much before this date. Much after this date.
March 2020.
Right. Notification is issued by the central government under the Disaster Management Act. That is the date on which COVID is effective in India. We have to go by the notification. We can't go by what newspapers will say.
Admittedly, account NPA declared on 19 Your Lordship, August 9.
2019. COVID is not a mantra, chu mantra for every. It's not a panacea before the High Court. No, bro.
Now
what happened?
Now, Lordship, even if after NPA Lordship, we have paid up to 2022 some amount, not regularly, but with the discussion with the bank, we have paid some amount, which we totally paid Lordship 8,30,000.
Amount due.
Yes, Lordship. Now, as on that, in both accounts, the due is 29,000, 22 lakhs, 29 lakhs, 22,628 dollars.
About 30 lakh.
About 30 lakhs dollars. And we have discussed with the bank Lordship for OTS, but that has not been finalized. But in the meantime, Annexure 3 issued by the OP3, the recovery agent, Annexure 3 page 62, for request for vacation and peaceful possession of the property Lordship. That has been issued.
Yes, you have
that is
to
the
property by mortgage.
My Lords.
Is it?
Yes.
Then abide by terms of the market.
Yes, that is the cause of action Lordship. Now that is issued on 19/6/2026.
19/6?
2026 Lordship. Just
possession notice.
My Lords.
13/4
possession notice that section 14 has been complied in 2019.
My Lord.
You might have been asked to vacate the quarter in 2026.
There was 14 orders.
Yes.
Some of the other litigation going on since 2019.
Yes, we paid some amount and now we're ready to settle the amount into OTS scheme Lordship. Bank also not documentary, but orally they have agreed to settle the matter through OTS Lordship.
When the section 14 order was made?
Section 14 order Lordship, that is
6/2019.
Annexure 2 page 63. The permission from the collector to.
Subsequently, NPA is made 7/8/2019.
Yes, my Lords.
May not.
Yes.
Much before that.
But in the
in August only. After this, how can it be?
But in page 27 of Lordship, kindly have a glance. Last NPA date, that is mentioned a date 7 August 2019 Lordship. So for the second loan Lordship. Yes, that may be, I got the date from the statement Lordship, page 27. Yes.
It offends minimum banking jurisprudence.
My Lords, that may be first loan, that may be, the date is not there. That, yes. Now, look, my predicament, I pay some amount of Lordship, let the bank to OTS, final OTS amount be finalized. I will.
14.
My Lords.
After 14, where is the scope for OTS? After 14, where is the scope for OTS?
They are agreed Lordship.
What they can agree? They cannot agree.
The only residential house Lordship. We're ready to pay Lordship.
Now write entire money. They will leave.
The reasonable time Lordship, they discussed with the bank Lordship, they agreed for OTS Lordship.
See, it's a loan agreement.
Yes.
Once agreement, pacta sunt servanda, is the foundational principle of contract law. Whatever you have agreed to, abide by it. That's any standard book on law of contract, like Cheshire, Hayford, Punxton, Mulla, Pallon, and Sons. All they say, chitti on contract. All they say, what you have agreed to, abide by it. Unless law relieves you from that. No such law is being argued before us. You have taken money.
Yes,
Try and put that money into the pocket of
Yes, Your Lordship.
along with the interest. Any argument is inconsistent with the loan agreement and unconscionable also. Having taken money, dragging the court, the lender to the court, troubling the lender, a good thing to happen in writ jurisdiction. Writ jurisdiction is for honest gentlemen. Is it?
I'll pay.
You should have paid. Why? We are not the parties to your loan agreement. Whether court is the signatory. Why you tell all this to us? Go and tell, go to the bank and carry the money back, pay it back. They will be very happy. No writ jurisdiction. It's not public money, your money, our money.
Yes, Your Lordship. Only I'll pay some amount, Your Lordship. We'll approach the bank for OTS. We'll approach the bank for OTS, Your Lordship. That will be considered.
Saying anything.
Till then, Your Lordship, I'll pay 10% of the account, Your Lordship, and approach the.
You can go in Katak Street for buying panipuri.
No, my Lordship.
You pay money, whatever you want to take.
The coercive action, Your Lordship, that will.
It will follow.
I'll pay 10% and approach the bank for OTS.
We'll request him to give some reprieve to you. You pay 50%.
Unable to pay.
Let him sell the property.
50% unable to
The
pay.
property. Take us.
Your Lordship may consider. Your Lordship may consider.
What can be done? Suppose
They have agreed for Your Lordship out of court submitting. Bank will agree for settlement to OTS, Your Lordship. They have agreed up to 13 lakhs. We have agreed to up to 10 lakhs, Your Lordship. The one week back, Your Lordship. That discuss, Your Lordship, but that has not been finalized. Meantime, Annexure 3 has been issued, Your Lordship.
Sit before the bank.
It's only, I pray, Your Lordship.
You are more closer to the proximate amount that you need
Yes,
to
yes,
pay
Your Lordship.
than the one we are asking you. So better you negotiate with the bank.
Yes, I will negotiate due to this Annexure 3 will only the petition before Your Lordship. Now I will pay 3 lakhs, Your Lordship, around 10%, Your Lordship, 3 lakhs. Then approach to the bank, Your Lordship, within 15 days, they will consider the OTS application. So whatever amount will I will pay within 120.
We can't tinker with the terms of loan agreement. We cannot tinker. We are a writ court. We have to do things in accordance with law. We cannot do. Maybe difficulty may be faced by you. That's another thing. But we have to abide by law. Justice according to law. We are not muggles.
Yes, innocent poor persons, therefore, avail the 12 lakhs, 8 lakhs already paid, now 30 lakhs demand is there.
You pay that.
Taken 12 lakhs, 8 lakhs paid, now 30 lakhs
If you pay
demand.
15 lakhs, we will give you 4 weeks time.
They have agreed for 30 lakhs,
You can't do that. It is cheaper.
So-
You came to
That is what I said.
We are costly. All right, you don't waste time. You argued beautifully good for the case. Anything you want to say to dilute our view? Yeah.
They permitted to withdraw to approach the bank office.
Petition of the counsel for the petitioner, having vociferously argued the matter for long, now seeks leave of the court to withdraw the petition to pursue his remedy elsewhere in accordance with law. Do you have objection for learned panel counsel appearing for the bank agrees with this proposal very graciously? First, we appreciate that. Next, in the above circumstances, petition is disposed of as having been withdrawn with liberty to the petitioner to pursue the remedy elsewhere in accordance with law. And in that connection, all contentions are kept open. Yeah. Yeah. All right. Next.
Please apply 1030-2025.
Yes, sir. Yes, madam. Who appears for the
Immediately petition. Immediately. Batch of cases arising out of the common session. I am in one of the cases appellant, my non-claim is the first case concerned, my non-claim is the appellant. You know, since the last application, director issue notice by registry.
yeah,
Also by petition.
Special message.
But notice have been issued, but it has been answered to some of the respondents.
not served?
Yes, particularly.
Not served because it is not been paid.
No, it is filed. In the case it is
The
filed.
noting is that requisite has not, first, special messenger has not been filed. You not have quantified the amount.
1,000 rupees we directed.
You must have
They
directed.
filed, it is served. But
That
some
is the
case,
noting.
some person
No,
they didn't
Mr.
appear.
Das, Mr.
Second case.
Das, in one of his case, it is not filed. I mean, what a noting is showing. It is for
In which case?
All cases have
71 month.
Okay.
Yes.
In your case, you appeal.
I have cases, 7, 8 cases. One case is not listed today. All cases I have filed as per the registry calculation.
In
What are the-
117.
Then anyway, service has not happened.
Yes.
So without service, you cannot take.
On some of the persons that did
My
appear.
problem is, now they are proceeding with the contempt.
Your Lordships.
They have filed a contempt and that matter is posted to 25th.
Now, Your Lordships, they are the appellant. We have a judgment in our favor. They don't do what they're supposed to do and make it complete for hearing. And we were on caveat. And now they will press for a stay, Your Lordships. Somehow does not fall in the ambit of.
The appeal is filed. And you want to prosecute the contempt.
No, Your
Otherwise,
Lordships.
contempt.
State has not filed an appeal.
He is aggrieved and here.
Yes, Your Lordships, then we heard. What I'm trying to say is let
How
it
can
be
it be
heard.
heard unless all parties are served?
Your Lordship,
Tomorrow they will say.
May I say, Your Lordship, what really has happened is, we were the petitioners. So obviously, Your Lordships, we are the respondent here. Those respondents have appeared, who are the petitioners. But some of them who were opposite parties there have been made pro forma respondents here who are with them. They have not appeared.
Are they made a pro forma?
Yes, pro forma.
They said pro forma.
Yes, yes.
Yes, Your Lordship. We had checked, if Your Lordships remember last time.
No, where is it? Show it
Yes, Your Lordships.
from the pleading. They are only pro forma respondent.
Yes, some of the it is the pro forma respondents who have not appeared. For
Is
example,
it your version or is version of the appellant?
no, Your Lordships, why I am saying this? Because for all the litigating respondents, I have appeared in all the cases and Mr. Das has appeared in one of the cases.
But what-
So that's why we know. They have made, Your Lordship, an example.
We should notice in some of the cases he served, in a few matters it is not served. So prima facie we have found that it's a case worthy of issuance of notice.
Yes.
But now if you go on precipitating the contempt matter,
But-
what should happen?
This is one such case, my lord, with your lordship's permission. My lord, this is one such case where all the opposite parties who were the opposite parties in our writ petition, now some of them has come up challenging the order, the others have not. The persons who have not come up in challenging, they have been implemented as opposite parties along with us. We, the writ petitioners before the single judge, we have already appeared.
All appeared.
And they, so far as those petitioners, those opposite parties of the writ petition, now they would have been the petitioners who preferred not to challenge. In respect of them, the service is sought to be completed. And you'll also may kindly also see, since when this honorable court has been insisting upon directing them to ensure the service of notice by filing the requisites.
Direct police service now.
Service.
Will issue police notice for service.
And because of this matter, the other day, your lordship have also heard me that I appear for the promotees who are going to retire. Some of them have retired in the meantime. Your lordship took note of that fact, and that is why the matter was specifically fixed to today with ensuring service through special messenger. But till today, that has not been ensured, and the noting says the requisites for this special messenger has not been submitted. That is what the registry points out.
Is submitted.
Who should pay the requisite fee?
It was
Well,
inside. Yes, appellant.
That was
Can they allow? In the cases I have filed, my lord, I have already deposited the special messages because age assessed by the office.
How much money you hold? We have
2,000. Yes, sir, 2,000. We have taken both. By speed post, we have taken notice as well as special messenger. Now the noting is in the second case, my lord, I pointed out. There, my lord, they have not appeared, but notice has been served. They have not appeared.
It is in respect of which part number 11 to
My lord,
22,
second,
who are performer.
my lord.
They are performer.
Yes.
But in case the first case, my senior Mr. Tripathi is appearing,
The effect
they are
opposite parties.
respondent number, first case, notice against respondent number 1 is backed with endorsement, no such person in my feet, hence return to sender. This is the first case, there is a routine.
And then
Before that, my lord, neither AD nor answered notice for respondent number 7 to 10, 12 and 13 is back. We have already filed, my lord, at the earlier occasion, we have filed special mention, speed post notice.
No, there is notice to special messenger as per your lordship's direction dated 4/5/2026.
So we have deposited 2,000 rupees.
yes, in that case, if this is an old noting, according to them, they are submitted as an old noting.
Why you are spending so much time?
Yes, your lordship.
Take up unless all notices are served. Number one, now you take the steps in respect of R11.
My lord.
R11.
Yes, please.
Yeah. Issue police notice into R11 in writ appeal number 1030 of 2025. In that connection, the appellants shall deposit with the registry a sum of ₹1,000 immediately. Yes.
Well, all these persons are working in secretariat at Bhubaneswar.
Therefore, we sent police notice.
Yes,
we understood that something is not good. We understand that also.
Yes, well.
So whether they are trying to avoid the bench or what?
Yes, my lord. This is what our apprehension is.
Yes, that is what happened. That's a very short point.
Yes, I am ready in this case.
So we pray
In
your
respect of others, whether
In the second item,
yes, my lord. It
the
has been.
notice has served, but they have not appeared as noting says 80 not back, because both ways I have taken notice. 80 not back from some person,
So there will
but
be-
special message notice served.
So it can, the notice respondent of 15, 17, 18 and
Okay,
20 is back.
good.
We don't know.
80, my lord, may I read my lord?
yes,
This is additional affidavit file so and so. SR service return of special messenger received from R7, 14 to 19, 23 and 24. Neither 18 nor answer notice for R15, 17, 18 and 20 back. 80 from R7 so and so is back. T number for which respondent not filed. So
which response is there?
they are the some of them are the pro forma, some of the opposite.
In R9,
Yes.
kindly see R9 notice is returned.
Not returned.
Returned. Unserved notice for R9 and R10 is back with a noting of insufficient address.
Yes. R9 is
Steps to be
the
taken in respect of R9 and R10
this
by way of emergent notice. In companion writ appeal 1044 of 2025.
We have appeared.
They have already appeared.
No, 1055.
1055.
Lagun, your lordships.
1055 of 2020.
Here also,
No.
Lordship may kindly see
10.
respondent 9 and 10.
1044. Second
Due
case.
to insufficient address, it has written by 9 and 10.
Appearance, they have already
And for
appeared.
respondent number 8, it is also back.
No,
So,
1055.
Response
Notice has
of
not been issued because of non-filing of the refugees. That is also in the endorsement.
Response number 8 in which writ appeal?
My lord, writ appeal 1055 of
1055, neither 18 nor answered notice of R8 is back.
Yes, Lord.
Therefore, presumption of service arise.
Yes.
Then also notice for respondent number 9 and 10.
That we have already ordered.
Insufficient.
In respect of others, it has been already served.
My lord.
In respect of all other respondents, notice is deemed to have been served. In as much as neither the envelope containing the notice nor the acknowledgement have returned to the sender by virtue of CPC presumption. Can somebody tell us which is that provision in the CPC where notice sent, it does not come back It should be deemed to have been served.
Order 519,
In terms of Order 5, Rule 19 of
19 capital. And also the general clause set.
Yes,
there is a proof.
Resumes.
Yes.
The contempt is concerned.
Your Lordship.
Next date of hearing, the content proceedings the proceedings in contact number.
Well,
2237.
well, there is no order in that case. There is no order. Only the contempt has been
We'll
filed.
proceed with the
Because there is no.
Learned advocates appealing for the other side undertakes before us that they would not precipitate the contempt.
Yes, Your Lordship.
Next date. Your Lordship,
Till next date.
Your Lordship fix it matter next.
After this.
No, Your Lordship fix a date because of Your
Yes,
Lordship.
unless service is done. Court will get the power to fix the date
My Lord,
only after service.
My Lord, kindly weigh the predicament. Well, they are working in secretariat. They are getting one after the other, promotion one after the other during pendency of this litigation.
may I just, one more here. Let the office update this also, Your Lordship.
Yes, registry to update
Please notice.
the published.
Publish notings, Your Lordship. What happens is normally they don't come to the same.
My Lord, one aspect, my Lord, even if all these matters are analogously taken, the opposite parties are jumbled. In one case, somebody is R5, the other case is the R15. Even if he appeared there, he is being shown insufficient here.
Where he appears.
Well, in many such cases, we will find out.
We'll find out.
Right now, we would have done.
Yes, we
Given treatment so that it will be sufficient.
yes.
As far as the effective respondents are concerned, all have appeared. It is the pro forma respondent.
Post immediately. Got it.
Oh.
But don't give an impression that you are avoiding the bench.
We are not.
We are trying the hearing here.
No, not you. We are also the other side.
Yes.
It's an impression.
It's a very short question of law, whether the seniority is fixed from the date of appointment.
It is understood. It is understood from this. You are going for 2010 rules, 2016 rules. The decision with regard to K. Megachandra, the Jagdish Patnaik, these are all consistent.
Yes.
The matter is already.
Yes. Madam, all these appointments were made when the 2010 rule was in vogue.
And we are conscious of it.
And
We should, our seniority should have been
They are
fixed.
relying upon the judgment of the court.
We
Exactly.
did it on basis of date of vacancy. So we finally have a judgment on the basis of date of appointment, which is not being allowed to be implemented.
Date of appointment.
But even if that is what the Honorable Single Judge has directed. That is what the Honorable Single Judge has directed. And the rule also says the promotees will be placed en bloc senior. With the promotees, we have been sorted down to the down below this director. That is what the Honorable Single Judge has directed to be revised. Despite that, enjoying higher position, they have been getting promotion one after the other. They have got 3 promotions. We are still pegging down. We are appointed in 2013. They came into the cadre in 2016. But still, they have, by showing them in the senior to us, we have been denied with promotion, which they are enjoying at least 2 times above us. And some of us have retired in the meantime.
Immediately.
Oh, bless them.
Yeah.
So, tonight, it's one of the
This is it.
Item 9, Your Lordship, you beg your pardon, Your Lordship. We need a week's time to check, Your Lordship, whether this compliance has been filed by the 9 and 10, Your Lordship, is the same.
9 and 10.
Yes, Your Lordship.
Your Lordship dispose of the matter with the direction to comply the order of the Law and Tribunal within a stipulated time period of 2 months, spelling with the compliance affidavit shall be filed before this court, for which the matter has been listed to.
I've checked.
Yes,
One.
I have not.
Next
It had
Tuesday, Your
to be
Lordship.
fixed.
Next
Let's
Tuesday,
put something. Yes.
7 July. Who bless you, Lordship?
9 and 10.
9. Call
I
together.
can tell you that resolution 120/2026.
Please, what is error apparent?
Well, this case has been filed after a development has come into existence. My lords, your lordship will recollect here. It relates to the my lords re-engagement into service.
Where is the error apparent on the face of the?
Yes, I am showing that, my lords. So subsequently to the disposal of the writ petition, our writ petition, my lords, there was a development that a similarly situated employee who was disengaged with me, he was permitted he filed a writ petition and that was permitted, and he was after that engaged also.
Is it error apparent?
It was a new development that has.
Read Order 47 Rules 1 and 2, which are made applicable to writ proceedings. Error apparent on the face of the record.
My lords.
If something happens later, how can that be error apparent on the face of the record? It was not on record at all.
At all.
But my lords, the proviso part, if I remember, my lords, the Order 47 Rule 1, the proviso to it says that if there is any new development which was not in my notice subsequently, my lords.
New development is also in the contemplation of law.
My lords.
I'm not very sure. My memory is playing trick with me nowadays. Which is that provision? I want to know. We want to know.
No, I'm just coming to that.
Order 47 has undergone a lot of change after 1976 amendment.
Application for review of judgment, my lords. I'm reading. Any person considering himself aggrieved by decree or order from which an appeal is allowed, but from which no appeal has been preferred. My lords, and who, my lords, I'm switching to the paragraph, my lords, and who, from the discovery of a new and important matter.
That was in existence. Lord Squire of Federal Court described this concept. Discovered means it was already there, it was covered, now it is discovered.
My lords.
That way. But where is the new development does not fit into parameters.
My lords, I think I'll have to, my lords, look into this portion.
It was a matter which was already there, could not be brought despite due diligence.
My lords.
It has to be brought. But in your case, it is subsequent.
Development.
It has come later.
Perhaps your lordship had only given me this opportunity, my lords, to file a review application where the lordship had heard the state had filed a rate appeal, my lords, if your lordship will recollect.
You had argued that matter so great.
Yes, my lords. Extremely grateful, my lords.
You had suffered earlier orders.
Yes.
Which you had not put in challenge. Therefore, we res judicated you.
Yes.
Maybe the word res judicated.
Res judicata will supersede the doctrine of parity. My lords, that is what your lordship had held. Lordship had given me the, my lords, liberty to file a review.
My lords. Liberty not necessary, because it's a kind of right also.
Yes.
Given by CPs.
Because of the time span, my lords, because it was a long duration of time since we were in another forum, my lords, we had filed a writ application without challenging this order. That's why.
But no ground made out.
My lords, I'll just examine this.
Take up the next. You take charge before some other judge. Because I am speaking to my
lords, I feel that this is the best court that can serve me justice, my lords.
It's our best in our court.
My lords, short date may fix, my lords. I'll come up next week.
But you don't take risks before the same judge. Try to get justice at the hands of some other judge. First, immediately after, in the last week of July. Yes.
Doesn't this demand say, you know, 25
Will be lordship occasion on behalf of the there is nothing, your lordship. There is a nothing that there is some typographical error which has crept in the order.
Order instead of 02.
Yes.
01 is
1, and in the cost title, your lordship, it should be authorized officer HDFC Bank, Katakil, not Bhubaneswar.
Oh.
That's the
in the cost title. The rectification should be to the effect of introducing Cuttack in the state of Bhubaneswar. Correct.
No, Lordship, it will be only in place of Bhubaneswar, it will be Cuttack. Authorized officer,
That is
SDFC
what-
Bank, let's say Cuttack.
SDFC Bank is there, but in state of
Bhubaneswar.
Yes, yes, Lordship.
and in serial number,
And
order. Order is serial number, it should be 1 instead of 2.
Order number.
It should be. On the second date of listing, it was.
How it makes sense?
These are all friendly. We don't have any officers.
It has come on. So more to you.
That is an order of that particular case. That is one.
You find a year for that?
No, you know, just so.
It has come from the officers.
Yes.
Registry has pointed out some mistakes in mentioning the city as Bhubaneswar instead of Cuttack in the costing. First, the mistake needs to be rectified. Next to be to justiciary. First number. The other aspect pointed out by the registry as to order number fails into examples. Order number 1 invoice fails into examples. Issue fresh rectified copy if applied for, free of cost.
That means that we discuss item 14, content, 2026.
Requisites have not been furnished. Requisites to be furnished within 3 working days. Failing which contempt proceedings automatically stand dropped.
Item 15, need of the 180 of 2025.
Well, it's item 15 to 18. This is similar matters. Your Lordship yesterday issued notice. That is writ appeal number 1800 of 2025.
Issue emergent notice 15 to 19, 18.
My lord, 15 to 18. 16, 17, 18.
Yes.
Item 19, need of the 1847 of 2025.
What is this 19, Mr. Bevra?
My lords, this is the petitioner was engaged in 2015, my lords.
In fact, the re-engagement order
was set aside. Set aside. And there was order for financial benefits.
Yeah. You forego financial benefit.
I am for the respondent, my lord.
Correct. You are not working during that period.
Yes, my lord, that is not the case.
Huh?
Case one, he was appointed on the basis of the selection committee, that is on 6/7/2015.
Selection.
Selection committee, by the selection committee, held on 6/7/2015. On that day, 94 rules was in force. 94 rules was in force. Selection committee was held on 6/7/2015. And on that day, selection was made in view of the 94 rules, my lord. In the meantime, that rules was amended 2015.
Slowly. In the meanwhile,
In the meanwhile, new rules, that is 2015 rule, came into force.
Earlier rules were 94.
94. That is, Lordship, Odisha subordinate statistical surveyors method of recruitment and condition of service rule 1994. On the basis of this rule, committee constituted there, they recommended my name. Lordship, then a new rule came in 2015. That is on 8/9/2015.
Earlier rules were repealed.
Yes, madam. But selection was made in view of the 94 rules. He was appointed on 14/12/2016. He continued.
Appointed
on 14/12/2016.
Just mark it friend.
Yes, ma'am. Then after completion of 3 years, when he applied for his name was recommended for salary. Then the deputy secretary directed the director to terminate him as because he was illegal appointed not on the basis of 2015 rules complying with the natural justice. But order was that to terminate his service with the compliance of natural justice. The director simply dismissed the service of the petitioner. Though prior to that, he has challenged that order of the deputy secretary and the order of status quo has already been passed. That is the case, and that is also categorically held by the honorable single judge. That you will also kindly have a glance to the judgment.
Mr. Bevra.
That's why the honorable
single judge wanted to disengage the petition as illegal.
Illegal.
Where is the illegality? The illegality argument arises because he kept the 2015 rules in mind. Whereas the selection took place way back in 6/7/2015 under the old rules, because new rules came into effect on 8/9/2015. Secretary wanted to whitewash entire history. He just focused on the new rules. No, nothing. There you go. How many days delay?
230 days.
This inter-court appeal by the state and its functionaries seeks to call in question a learned single judge's order dated 20 February 2025 NDBC, whereby respondent employees WBC number 21705 of 2019 having been favored, the relief has been accorded to him as under. We go to the paragraph 10 to 12. 10 to 12. Okay? 10.1, 11, and 12. Okay. Next paragraph. Learned HEA, Mr. Behura, appearing for the appellant, vehemently adjusts that the orders of the authorities could not have been voided by the learned single judge, in as much as what they had focused was the provisions of 2015 rules. And therefore, action was perfectly in accordance with the legal regime. Per contra, learned counsel appearing for the respondent employee draws our attention to the selection of his client by the selection committee constituted under the 1994 rules. 1994 rules. And that the respondent was appointed on 14/12/2016. That is, a little after the 2015 rules came into force on 8/9/2015. First off, therefore, he says that there is absolutely no merit in the appeal of the state. Next, having heard from the counsel for the party and having perused the appeal paper, we decline indulgence in the matter in as much as the selection committee that recommended the case of the respondent was constituted under the erstwhile 1994 rules. And accordingly, the recommendation was made on 6/7/2015, followed by regular appointment dated 14/12/2016. First of course, by that time, the new 2015 rules were promulgated, and that is where a gross error happened on the part of the authority who focused on these new rules forgetting what has happened under the 1994 rules. Personally, had they adverted to Section 6 of the Orissa General Price Act, is that it?
Yes, ma'am.
Which year? Orissa General Price Act. So and so. Come on, that error would have been avoided. First of all. Next one. Learned single judge, having considered all aspects of the matter, have rightly arrived at a conclusion favorable to the respondent employee and adverse to that of the appellant CLA. First, despite vociferous submission, no error apparent on the face of the record is pointed out, nor any ground for not sustaining the impugned order is demonstrated. First, we do not agree with Mr. Behura that the financial and service benefits would not have been accorded to the employee, in as much as there is a gross error on the part of the appellants here in appellant authorities. Appellant authority. First, an argument to the contrary would tantamount to permitting the authorities to take the benefit of their own wrong, there being no culpability attributable to the respondent employee. In the above circumstances, the above part, the appeal has been preferred by the state after brooking a long delay of 230 days. First, an application in I number so and so, supported by affidavit, is also moved, seeking its condonation. First, a bare perusal of the application and the affidavit do not demonstrate a plausible explanation for the long delay proved. First, in the above circumstances, this appeal fails both on merits and on delay. First, the impugned order of the learned single judge shall be given effect to within an outer limit of 8 weeks. 8 weeks. Next, we shall revert in a while, Mr. Mishra. Yes, sir.
Item 5.
May I please, bankers?
Yes.
Let's the opinion number 1 is the financer. That is Aadhar Housing Finance Limited. Aadhar Housing Finance Limited.
Aadhar Housing Finance Limited. Yes. Opposite party.
My lord.
Yes.
31st March 2023, the loan was sanctioned. The total loan amount is 18,72,428.
18.75.
My lord.
Housing loan.
Housing loan, my lord. My lord, the EMI begins from August 2023.
So 5 month
My lord.
No payment during the first 5 months.
My lord. That is the moratorium period.
Yes.
My lord, I have paid 3,33,082. My lord, that, my lord, I have stated in page 5 of my petition, my lord.
3,33,082. 3 lakh?
Again.
33,000.
Page 5.
All right.
Page 5, 3 lakhs.
On? That was paid on? No, that was paid in splits.
My lord, dates I have given. The last payment was made on 8/2/2025.
8/2/2025.
From March 25, the loan is not paid. But my lord, the loan is to be paid in 303 installments. That means in 25 years, 3 months. And this
It's a 25-year period.
25 years, 3 months. 303 installments total.
At the rate of 25,406. At the rate of, what was the EMI? Because you have, it is
Doing 25,406.
My lord, annexure, they have stated at annexure 14, annexure 1, page 14, the EMI 25,406. Thereafter, they enhanced it to 25,958.
That also you paid.
My lord. Now, my default is with regard to I am defaulted in payment of EMI, and that starts from my lord's March 2025. And now the total outstanding of EMI as on date is 4,15,360.
Who died?
My lord, paragraph 70.
Petitioner's grandmother.
My lord.
But she signatory to the loan agreement.
Sir.
Grandma was
Grandmother.
Grandmother was a signatory to the loan agreement.
No, my lord.
Yes, your grandmother's.
Those are the difficulties I have explained. Those are the difficulties I came across that I have explained in paragraph 7 of my petition.
And that prevented you not to repay. Anyway, you defaulted from
I am
March 2025.
paying the EMI, my lord, from
February 2025 was the last payment.
March 25. February 25 was the last payment.
8/2/25.
March 25 onwards, I am not paid.
Yes.
That's my case, my lord. My lord, I will pay. I am agreed to pay the 50% of the total defaulted EMI. My lords may grant me some time, and the balance area EMI I will pay along with the monthly installment regularly. But what they are doing, the OP1, the financer, he is not accepting the money in piecemeal. This is the problem.
Your problem. Why he shouldn't? There are terms of loan agreement.
The agreement is there. EMI is to be paid in each month. But for these reasons, I could not.
If you pay entire outstanding EMI within 1 week, then
50%.
No. What is the outstanding EMI?
They have said it is 1,29,590. 1,29,590. But in my calculation, as on date, the defaulted EMI is 4,15,360. That they have not said. This is my calculation.
you pay that your calculation. It is a matter of arithmetics. 25,958.
Sir, I will pay
into into 12,
16 months. 16 months.
That will be how much it will be? 25,998. 5,8 into 16.
My lord, now I cannot pay the entire. I will pay 50%.
You pay 50% is in 1 week. Remaining 50 another in next 1 week.
1 month, man.
Huh?
One.
But one within first installment within 1 week.
My lord,
Now what has happened?
some more time.
Okay. Now what has happened?
Now the section 14 order is there.
The order is passed now.
Order passed. That is at annexure 5, my lord.
Then go before the DRT. That was passed on which day?
My lord, that order was passed on 28th January 2026. 28th January 2026, the order was passed.
15
But no opportunity was given, no notice was sought.
Where is the question?
Where is the question of giving notice to you?
28th January 2026, the 14 order is passed.
You cannot maintain the will also. So it will be time always. What is the, how courts have interpreted section 17 limitation period? Is there provision for condonation of delay?
17, my lord, I have not examined.
Reading that you will not make out anything. Anybody on the banking law side?
The right to appeal. Any person in
No, sorry, right to appeal we have seen.
my lord.
Our question is bit different, structured on that section itself, text of the section. It says maximum period that can be condoned is also mentioned there.
My lord.
Whether beyond that period any appeal is maintainable is the question.
My lord. 45 days is there.
45 days is for condonation of delay.
My lord.
That's all. 45 plus 45 or 30 plus 45.
30 plus 45.
30 plus 45. So beyond 45, there cannot be condonation of delay. There are some high courts have taken that view.
Well,
So you received notice on?
April.
notice by
On
lord.
15th of April.
28th May 2025 is the tracking notice.
No notice. We should tell him earlier. You file appeal.
My lords grant me leave, but what I say, I will have to pay one day. Then if my lords will interfere and direct him to accept the 50% amount,
No, we can't.
I'm ready to pay it.
We can't.
So I may not go to the appeal.
No, you have to go there. It is meant for that only. We are not meant for this.
That's right, man.
But we'll give you some time.
My lord.
Okay? Now, because we'll reckon it from the date of
15, 4, 15. Received on 16, not 16 from.
You have challenged that section 14 order.
My lord.
Can be seated. Vasant.
Either from 10 term. 10 term.
14 was not served.
That is how we can be taken.
But section says from the date of the order. But anyway, we can. There are some provisions in the limitation which exclude
That
14, section 14. A defaulting borrower having suffered an order dated 28/1/2026 at the hands of the subdivisional magistrate under section 14 of the Surface Act 2002 is knocking at the doors of CORAM.
District magistrate, collector, and district magistrate.
Against the court's actions. Persons. Learned counsel for the petitioner borrower submits that loan in a sum of housing loan in a sum of rupees 18,75,000 was taken on 31/3/2023. The repayment period being 25 years, 3 months. Reckoned after 5 months of availment. And that the initial monthly installment was fixed at the rate of rupees 25,406. That came to be little raised to 25,958 later. First, he also tells us that the loan, the installments accruing due were paid from 10/8/2023 2/8/2025, in all amounting to 3,33,008. First, thereafter, the installments having not been served, the course in action, the bank resulted into obtainment of Section 14 order, now put in challenge before us. First, having heard the counsel for the petitioner and having perused the petition papers, we decline indulgence in the matter, inasmuch as the petitioner has got an alternate and equally efficacious remedy, if not more, as provided under Section 17 of the 2002 Act. First, we also notice that though the Section 14 order was made on 28/1/2026, that was a copy of that was obtained by the petitioner under RTI only on 16/4/2026. First, therefore, apparently, the challenge can be laid to the said order even now, the limitation period having not expired. First. Next, despite vociferous submissions of learned counsel appearing for the petitioner borrower, we are not impressed that we should undertake a deeper examination of the impugned order dated 28/1/2026 handed by the collector under Section 14 of the Act. No extraordinary circumstances are demonstrated either for taking a deviant route. First, it has long been settled by the apex court decisions that ordinarily writ jurisdiction cannot be invoked when statutory remedy of the kind does avail to the aggrieved, subject to all just exceptions into which argued case of the petitioner does not fit. First, in the above circumstances, this petition is disposed of, reserving liberty to the petitioner to avail the remedy at the hands of the DRT as provided under Section 17 of the 2002 Act. First, to facilitate availment of the said remedy, the parties are directed not to precipitate the matter for a period of 2 weeks. First, the DRT, while taking the proceedings now in contemplation, shall not be influenced even in the least by what we have observed herein. All attentions of the parties are kept open. We to send a copy of this order to the OP Bank for reference. Immediately. By speed action.
Till then, no question.
15 days we have taken. 15 days. Yes.
You may please your lordships.
Yes, sir.
This is an appeal against the order of the Hon'Ble single bench of this Hon'Ble Court dated 14/8/2025.
14/8/200.
Yeah.
The order itself is filed very short order.
It's cheese means and food for engagement and fair by short. Transparent and legally acceptable manner. Consequently, order to be fair by cost.
This matter is taken up through hybrid mode. The petitioner is a self-help group SSG pursuant to the advertisement dated 22/10/2024 for selection of a fair price shop for the dealing with PDS commodities. The petitioner group was one of the applicants. after a selection process, opposite party number 8 was selected as per order dated 7/2/25. The petitioner challenges such selection on the ground that the process of selection was not transparent and contrary to the guidelines. Moreover, the comparative gradation of the SSGS was made wrongly. The state has filed the counter justifying the selection of opposite party number 8. Had Mr.
OP in the petition.
Yes, my lord.
Appellant was OP in the
Referring to Annexure 7 enclosed to the counter affidavit filed by the state, Mr. Roth points out several discrepancies in the award of the made under different heads. For instance, serial number 3, even though the maximum mark to be awarded under such head is 10, the opposite party number 8 has been awarded 13 marks. Similar discrepancies have been pointed out under other heads. Mr. Roth fairly submits that his client has also been awarded marks not in consonance with the guidelines. As such, the selection process appears to be vitiated. In such view of the matter, the writ petition is disposed of, directing the sub-collector and licensing authority to revisit the process of selection SSG.
After cashing that order. What is wrong with this order, sir?
So, the opposite, the present appellant was an opposite.
OP number 8.
OP number 8.
You were awarded the 13 marks when you could have been awarded at the most 10.
The entire marks has not been calculated. The OP number 8 has been awarded about 97 marks minus 3 marks. It comes to 94. 94
will be higher.
Yes, and the president, the opposite party in this writ application was awarded only 1 mark. That is from 90 minus 1 is equal to 89.
My lord, there is delay of 49 days and there is a private party. Notice.
Say, sir, I have filed a petition for condonation of delay and also an application for stay of further proceedings.
But delay has to be condoned.
Exactly, sir.
Unless delay condoned,
yes,
we will have power to entertain your application for stay.
Exactly, your
that. Heard learned counsel appearing for the petitioner, who prima facie demonstrates that even if the finding of the learned single judge as to 3 excess marks being awarded in favor of his client is discounted, is accepted, still he would be the front runner, his score being 97 minus 3, that is 94. As against 1 mark secured by the petitioner, who happens to be respondent number
8.
No.
Here,
here
9. Here it is 9.
9 response number 9. First one, a case will be wrote for issuance of emergent notice, both on main matter and on the delay application. First one, issue emergent notice. Learned DGA Mr. Behura, on our request, accepts notice for
1 to 8.
1 to 8.
My lord.
1 to 8. First one, emergent notice to respondent 9. Response. Requisites within 3 working days. First, immediately after service for consideration of application for a hearing. Okay.
Item 21, in reference to the file of 2025.
And I think 21, madam. The file is misplaced, madam. I believe this matter will be taken up next week, madam.
At the request of. Dear appellant, who are you? We are not issued notice to you at all. Yes, please.
My lord, it's a matter of regularization of.
Correct. But how you are concerned? It is their appeal. They will not press it at all. Where is your voice? Your voice is sweet is another thing.
After serving 30 years as Group D, regularization has been directed following Jago and Shripad. That order they are challenging. Your Lordship is consistently relying upon those judgments.
2 weeks.
Obliged.
Let it come.
Deep.
How many years of service?
Service 3 to 4 years only left.
How many?
Already serving since 1997.
20.
Okay.
Next.
Item 22, need of 705 of 2024.
Yes, sir.
Since there are two appeals and he appears in person, let him complete his part.
Any urgency?
My lord, the opposite party have filed IA on the last occasion.
Where for?
For they have some
Additional evidence.
Additional.
This was in response to certain queries that your lordship had raised.
so it is their turn to complete. I have already completed.
Why is it that we will consider that application? It's a, it is
If they say something on that, then well, I have
you file objections to that.
No, my lord, my last suggestion is no additional evidence should be taken.
No, that you have to say in writing.
Yes, other is writing. I am giving my
You need time.
day after tomorrow.
Day after tomorrow, not possible. Week after tomorrow. Well, after 3 weeks.
Please.
In the meanwhile, objections to the application seeking leave to produce additional evidence may be filed by the appellant.
But the appellant in one of the appeals. He is the appellant in now
705.
705. I have filed the IA in
865.
865.
But he is not party. He is party.
He is the one.
By the respondent in instead of appellant, by the respondent in writ appeal number 865 of 2020.
Not listed.
2 weeks. 3 weeks we have given. You have to give a copy. They have to read.
2 weeks after.
Yes. Next.
Item 23, need of 31 GST official number 4.
That's item number 23. I'm appearing on behalf of Shashwat Das, who is the panel counsel for OUT. There is a change in the panel. Therefore, we have been given oral instructions to appear in the matter, mellows. We have not been able to obtain this Vakaratnama because one of the appellants, that is the Vice Chancellor of the university, is out of station.
How long he has been out of?
He will be out of station till Monday evening.
Monday.
So Tuesday we will file.
Tuesday.
Mellows.
Yes. Sri so and so, learned panel counsel appears for the appellant in the stead of earlier panel counsel Mr. Manoj Kumar Khuntia. We have to delete.
Yes.
Registry to delete Khuntia's name and print the name of the new panel counsel.
Who is that? Shashwat Das.
Commissioner will have it Tuesday. Monday, Vice Chancellor is coming. Whether Vice Chancellor has to sign the wakalat?
No, it's Vice Chancellor and the Registrar. The Registrar is present, she has signed it. But the Vice Chancellor has not signed it, so we have not been able to.
Under your act, just other day I saw, it is the Registrar who represents the university, not Vice Chancellor.
And she can sign the affidavit or the
Registrar can do.
But the Vakalatnama has to be signed by the Vice Chancellor. That is.
All right. Well, we'll say that you have been authorized to represent Vice Chancellor. Are you authorized?
My lords.
Then all right. Where is the question of this statutory body?
My lords, my learned senior Shashwat Das is the panel counsel, so he has been authorized to.
Therefore, we are waiting that. Recall that. Learned panel counsel, Mr. Shashwat Das. Shashwat Das, on being authorized by the appellants, represents them in the stead of Mr. Manoj Kumar Khuntia, the erstwhile panel counsel. First off, registry to print the name of the new counsel after deleting that of the earlier one. First. Next week we'll do that. Call this matter next week at the request of the new counsel. New panel counsel.
Deeply, please.
Yes.
My lord, item in 24, my lord, in previous occasion directed to categorically that they should have to implement my lord's order by granting all the pensional benefits and the promotional benefit consequential one. So in it order dated 25
Is not allowed to speak. We are filing
No, not-
affidavit. Will comply with
Give
the because process started. Paragraph 8, that's why I'm speaking.
Within what period you are complying?
Within 1.5 months means.
1.5 months.
No, is it
What was the
categorically
period?
taking
Explain why.
No, no, question.
Yes.
Question is whether any period was prescribed by the court for compliance.
deliberately avoiding, my lord.
My lord has.
But you have
I'm just
mentioned,
reading my lord.
Mr. Pari,
Yes.
in your affidavit at 8, Parai,
Alright.
you have asked for 6 months.
My lord, from 20 till now, they are not getting a single pie and suffering a lot in cardiac problem and other.
Cardiac surgeon or cardiac patient?
Not sir. Patient.
Page 4 from 3 onwards, paragraph 8 Lord Chief.
What was the order?
The order is I'm not order 25/2/2026.
Lord, my lord, I am closing.
So ticket won't on instruction of the officer of the Santosh Kumar Mishra, assistant personal officer, such and such, was submitted that the petition
You
would
are
be
playing.
granted promotion.
You are playing. Sit down.
Well, boss.
Friendly, sit down. He did not hold folded hands before us. It's a matter of right. He has every right to come before the court.
Granted promotion to the post of chief officer, superintendent, that is, his immediate junior was granted and all his terminal benefits should be settled, including the financial benefit of such promotion.
What are the requisite documents and particulars? You tell it. We will get him right now.
But they are saying that on the process of
All the story will not tell Mr. Pari whether we have to issue arrest warrant or they will comply with the order.
their complaint.
Yeah, right. We'll call it tomorrow. Let them comply today.
But tomorrow that was not
Then
possible.
we will pass our order.
Because let me visualize my issue. What helped me for getting in the promotion, all these things required verification.
What are those things you want?
All these.
Give us.
The way I explain is good. Let's see. For a moment, let's see.
Mr. Pari,
I'm just reading.
Mr.
For a moment, I'm reading.
that will not help you in this court. This court is very much after compliance.
Just
No cock and bullshit.
1 minute, man. 1 minute. The implementation of the said direction, several official formalities and procedural compliance are required to be undertaken, including the verification of service particulars, fixation of pay, processing of pensionary and retail benefits,
And
and scrutiny of the necessary documents till the punishment.
What did they do all these days?
They want 6 weeks time. Lord may reduce any date. Lord may fix cut off date.
Why time? It's when the order was made. Order was made.
That's why you are implementing. You are not aware complaint to court's order, man. Only some period is required, man.
Mr.
Lord
Pari,
I am left to the court, but Lord fix any date by which the officers will come back.
and they will not complain because that order was made on 4/5/2026. And today we are on
What happened
23rd.
after my lord's order, something I am not that was going on. Then my lord was passed. I have given all this instruction to them. Accordingly, now it was processed. It may be completed within few days also. They have done it. You have given the all possession with all benefits, with all consular benefits.
Question is why it was not done till now. It is not the sweet will of the government. Government is under law. What was your undertaking? Kindly come to para 3 of the order dated 4/5.
4/5.
Yes, it was your undertaking, which we have recorded. You are a vociferous arguer, very good advocate is one thing, but very complex. Our voice may be low, but action will be very pungent.
I can't protect a person who is not with it.
Para 3.
Yes, I got
Read para 3. It's your
in
state.
the above circular, the opposite parties are directed to implement the order dated 25/2/2020, which records the undertaking within 2 weeks, failing which their deficiency may be
Defense may be struck up.
Struck up. Defense
So
will be struck up.
that's why I asked them to file an affidavit.
Ask
And
them
not may
to-
consider this and give some further more time.
No.
They will.
No time given. We will direct not to pay, they should not be paid salary till the work is done.
Yes.
Well, what I am praying, my lord, Lordship may fix to 6th of July.
6th of July.
6th of July.
No, why that has not been done till now?
It has been done, but only where there. What happening for compliance of this, all these things they have to calculate all.
They
the
shall
records.
not draw their salary. till compliance is reported. We are inventing new ground for ensuring compliance of court orders. For at least for 3 months, they shall not be paid the salary. After 3 months, arrest and detention. One concession. Immediately, if we arrest, they also have spouses. They have children. They may curse us. What kind of curt judge from Karnataka has come to cut us for? He's a curt judge. Bloody curt judge by blood, bone and flesh. I am curt when it comes to implementation of the orders.
So what? I am not paying more by my lord. Yes.
Tomorrow.
Tomorrow is very certain. 6th of July.
By our order, they will do that. Don't worry. We know how to do.
On next Monday, is it Monday? Next Monday. Monday is 29.
You will comply with that order.
I think so.
No,
they
if you say then, otherwise you will pass order now.
No, what I am praying, my lord, give only 10 days. And 6 days, only 10 days. So within 10 days, nothing will have fall, my lord.
No, something will follow. The poor employee.
Yes,
for the officers, no problem. They will get money in the sense salary. Other things I will not say. So, comply with the order. Let them not talk.
3rd of July. Next Friday.
Next Friday. No. So, they have not done anything.
No,
what they have done, no, Mr. Paddy. We are very curt in implementation of the order. This court suffers from non-implementation of our orders.
Next week, any that
the litigants are suffering. Really, I tell you. Many litigants come and report to me when I go to Mahaprabhu's temples or some other temples. They say, sir, at least now the orders are being implemented. But otherwise, citizens will be unhappy.
I am considering
what we are giving orders, so what is the use of orders? They will look into the order and put into the dustbin. What is happening in the state? Contempt law has committed suicide, if it is not already murdered.
After 2nd July,
our order dated 4/5/2026 at para 3 reads as 3 and 4 reads as first one. Today, Mr. Paddy, learned DST, has filed additional affidavit and submits that the compliance would be reported within on or before 3rd of July 2026. First, no explanation is offered as to why the order has not been complied with till date, except saying that the process is on. First one, that will not be compliance, not a justification for non-compliance. First one. Next paragraph. In the above circumstances, we wanted to restrain the respondents. Respondent.
Opposite parties.
Opposite parties from trying their salaries till compliance is of the order is reported. First one. However, very reluctantly, we are not doing it now, in as much as Mr. Pari very fairly submits that the order dated 4/5 will be complied with in letter and spirit, and the compliance would be reported on the next date of hearing. First of all, believing his words, we are posting this matter on 3rd of July with a stringent warning that stringent action would follow should compliance report be not filed. Share a copy of this order. Register to share a copy of this order with the learned DST right now. 3rd July is Friday. Then 2nd July. 2nd July.
Let's say 6th July.
6th July.
6th July.
Next date you should tell them.
Yes.
First, no salary.
Today,
thereafter, arrest warrant.
Yes. Today.
This case follows the retirement happened on the 28th of February.
In this case, I have been.
But in this matter, sir?
My lord, this is around arising out of the review petition. Review petition dismissed.
then review, he has filed a review dismissed. Thereafter, he challenges that order. Before in the appeal, I have the instruction to appear. I file wakalat, lordship can.
I'm retired on 28th of February 2017, the last day only of my retirement. After 35 years of service, I was handed out the disciplinary proceeding. And the impugned disciplinary proceeding law was initiated purely on the mere facts. The allegations have no foundations. Just
What are the charges?
But the charges are this, 30 lakh rupees. Just
defrauded.
There are 8 charges were made against me. Rupees 30 lakh rupees cash was deposited by my relatives in their respective accounts. Not only within the region where I was posted, that is Varanasi, also outside. Means there are running accounts going on for a number of years. They're all business people. They're all doing their services, their friends, their relatives. 15 accounts were drawn as if there are no other friends and no relatives. 15 accounts, they say that within a period of say about 1.5 years, amount of 30 lakh was deposited in that account. How does that?
How are you related to them? How are you related to those account holders?
My daughter, my son, my wife, my friends, my other relatives, distant relatives. I'm from Orissa. I was in Varanasi. The accounts are operated from across India. They are doing businesses.
Let's show that what business they are doing.
They are all part of the evidence.
We'll just dig through.
Just kindly have a look at it. The page number.
Your wife and your children's accounts will come to what they are doing. So kindly take us to the evidence.
Right.
What were you?
I was the general manager of a bank, Union Bank of India. After third, yes, Lords.
And in fact, one of the nationalized banks.
My Lords, in fact, the inquiry report is exonerating me on 8 occasions, saying that there is no linkages. Well, somebody is depositing an amount in their respective accounts. I have nothing to do with that conduct or a misconduct. Now, your Lordship may just see that. I've given the written note.
No, what your wife and children are doing? How much money in the 1.5 hours is deposited in their account?
My Lords.
How much money is credited to their account?
30 lakh rupees.
Totally 30
yes,
lakh.
Over a period of 1.5 years.
What your spouse is doing?
Well, she is running a sports unit. My son is also running the sports units is there, but it's part of the record. That's yes, now just have a look at it. Your Lordship will see.
Are you ready in the matter?
Right. I have your Lordship may keep it to next week and file a report. And I have also filed one writ appeal.
You also filed it?
Yes, because
that to be called along with this.
Yes.
But the portion of the order which my learned friend is aggrieved of, just a moment, is regarding the withholding the retirement benefit, where that was an order passed in my review order. Review petition.
Just a minute. After holding the review is dismissed, is it open for the single judge to give subsequent any direction, whether it is permissible under review?
Because
that is the core question I have filed.
The substantive order in the rate petition, what I was aggrieved of, is that the component of my prayer was not considered A, and B, the component of my prayer regarding the disciplinary proceeding being illegal. The violation of Regulation 24 is not even adverted to or decided. That is why I came through a review. And the review of the court has gone into a portion of the order, corrected the order. That's why perhaps my learned friend is aggrieved of. On the finding that there is absolutely no loss to the bank, not even a single penny, not even their case, not even they could show it in the rate petition. That's why my learned friend would be aggrieved of only to that extent. Whereas that entire amount of retirement benefit is withheld.
No, but the point which he raises is, where review petition is dismissed in a wholesale way.
That is exactly what I'm also aggrieved of.
What relief could have been granted by the review court?
Yes,
to you.
Precisely. That is why I came before this court challenging the review order. A piecemeal order could not have been rendered. Of course, that's the law. My Lord is right. Taking that as a cue, my learned friend is withholding my retirement for the last 10 years now.
What happened in the inquiry?
Well, the inquiry report, just a moment. My Lord, the inquiry report found almost all the charges on facts, fellows. Like, for example, one is a deposit of 30 lakh rupees within a span of 1.5 years. That is within that region, the Varanasi region. There are a second, out of 30 lakh, they say that about 15 lakh something a payment deposited by concerned persons. This is second charge. Third, after I got transferred from that region, they say that in that respective accounts, there are less deposits. Post that, I was removed from that particular positions, from that particular region, sent back to the Mumbai. So after that 18 months, they say that your deposit is less deposits. The third charge. Fourth is there is a discrepancy in the leave encashment. Like for example, because my job was in the nature of the job where I was supposed to get the travel allowance, which the travel allowance has to go to my the salary account advance. The other actual amounts when I deposit it, then the rest amount will be deducted, will be deposited by account. So what they say, why there is a discrepancy in the salary account where you received X amount, whereas you spent Y amount, not realizing the fact that I have paid that amount of money even through other modes beyond the salary account, like a credit card and other card, which is their card. Then also the money which has been credited to the accounts is actually the insurance maturity amount.
Date of bill number?
DWA 27632 of 2025.
Just write down in you.
I request for the day after tomorrow I am here. Your lordship's can. It is 10 years rules. If your lordship, it is subject to your lordship's.
Because he has to prepare, he said he wants to file objections to this.
Well, today is the 5th date.
You can come to
next week.
Puri. This is a holy place.
No.
There is no restriction for lawyers to come here. Any number of times lawyers
it is always a pleasure coming to my hometown. This is my hometown.
Yes. We'll keep this matter on 8th of 9th.
No, sir. May I just request your lordship for my... Your lordship says
8th of July, all right, sir.
9th.
Just check your diary.
Can it be brought on 8th of July?
Yes. 8th of July. Yes. We just need to print the name of the net panel council. Panel council appearing for respondent numbers.
Only respondent number.
All respondent.
Only.
Rank. 1, 2, 3.
Yes, ma'am.
1, 2, 3. Wow, but that Dr. Seema Sharma is whom?
That is inquiry officer.
You appear for why inquiry officer in made a party?
He has made a party.
I made her a party, but I have some allegations against her.
Personal allegations. Then
probably, I think during the course of the writ petition, I did not. No notices issued to the inquiry officer that perhaps it will meet the fate of my making her as a party. Your lordship may treat it as a pro forma party, or maybe your lordship did not have to issue the notice also. That's not a relevant also at this stage. I'll not be burdening your lordships to get into the allegations against him.
Notice to respond number 4 is dispensed with on the submission of learned counsel appearing for the appellant delinquent employee patient that he would not be pressing the personal allegations made against the said respondent. First one. 1, 2, 3. Yes. Follow along with the yeah.
Writ appeals. Then we complete our pleadings by filing 2 further affidavits into each of the cases, and we have served copy just now to them, and we complete our pleadings by that. And if Others are prepared, I can argue, but Lordship may. Lordship may.
Even if he has served the copies the affidavit just now, but we are prepared now. Because your Lordship have already concluded, and your Lordship have already
Not concluded, it requires some submissions before your Lordship for further preparation. And consolidated preparation, Lordship may grant one more adjournment, short adjournment to any other date, my lord.
On 8th you do.
On 8th.
But again, don't ask me.
No, absolutely not. Absolutely. We complete our pleading, Lordship may record. We complete our pleading.
Anyway, simply we'll adjourn it on 8th and that's it, Your Honor.
Great.
just people now. Lordship have time. Lordship look to your Lordship's order dated 21/4/2020. Lordship framed two issues. And your Lordship have directed them to file affidavit. And we have also filed affidavit on the basis of the informations. That is the entire thing.
Remember, in fact, there were ex officio
Yes, sir.
holders of the office.
Finance department was a party to the decision.
Yes.
So, and your Lordship specifically asked whether the budgetary provision was made during 2017 and 18. Yes, themselves have filed the affidavit. Yes, budgetary provision has been made.
We will explain that. We'll show for it.
Audit, whether audit has been made or not, they said audit had never raised any objection. Third, the question is, so far as the authority of the management to take a decision, they don't have any reply at all. At that meeting, that is very important, which you are asking about.
Yes, that day we will.
Taking up on 8th month. At 2 p.m.
At 2 p.m.
Grateful.
Article 26,
May I please? Earlier, your Lordship has heard the matters in detail. Regularization of the workmen, these two scheduled caste employees, say working in the bank since 94-95. Your Lordship specifically directed, last order, your Lordship may kindly see, 18/5/2026.
We are asked to sit under the shadow of a tree.
Shadow of the tree.
They called us during summer.
They didn't call us on 19th, they call us. We came up with 3 proposals, but they did not. They did not.
During summer, there was no shadow.
No, Your Lordship, no, in fact, Your Lordship's effort was really appreciated, but actually they considered it. They called them, they had a sitting, 2 officers were present who were authorized to represent the bank. And there was a discussion. Bank informed them, kindly see, we are ready to compensate you because as per the policy decision, it's not possible on our part to regularize. And therefore, you kindly accept, because Supreme Court decided in 2023 in one matter of the bank relating to the same subject matter. I have also given the reference that instead of regularization, you pay them because they have already taken all the wages and salary, whatever they have been given. You pay them 5 lakhs at a time money. And that Supreme Court decision is there. But State Bank is a party. The bank went to the Supreme Court and Supreme Court settled the matter saying that.
In that case, how many years of service was put?
So it was long years, in fact. They're exactly like our case. And they are actually not by the court order. They continued from time to time, extension was granted. And they were permanent, temporary employees. But here they are daily wages. And in fact, by virtue of the Honorable Court's order, they accepted in letter and spirit the order of the Honorable Court. And they allowed them to continue in spite of the fact that it has been outsourced. Outsourcing party, they are doing the work. But they have been, these persons are also allowed to be there to do the menial work, and they have been paid their wages. There was at a point of time, revision of pay that was not paid. When they raised an objection, the differential amount of more than 1 lakh was also paid to them. So this is the increase of the daily wage amount, because Your Lordship knows the wage varies from 6 months to 6 months. So the variation amount has also been paid. So at one point of time, bonus was paid to them by mistake, in fact. So bank has recalled that, saying that, no, we are sorry, your daily wages, the wages are, the bonus is not liable. They have recalled. The challenge in appeal, that was also confirmed, saying that they are not entitled to. And Your Lordship also, they raised one point that during COVID, actually, a certificate was given that they are temporary employees. But we have explained that for commutation purpose, because if you don't get a certificate, the police don't allow you to come to the bank. So that's the reason that was also issued. That was also condemned, that the person who was issued said that you can't issue something which is not there on record. But we tried our best, and we say that let them be paid 5 lakhs of rupees at a time.
5 is too meager a sum.
But 5 lakhs, we have said, we have offered them 5 lakhs.
You began with 5. Any journey begins with the first step only.
Right, absolutely right.
So if you travel little above, then we can tell them whether to consider or not. Otherwise, you have to decide the matter on merits.
Yes, exactly. That's exactly.
That may be
so bank is candidly before a lordship discretion. Bank says that we can do within the framework we have got the policy decision because there the public sector undertaking.
My small contention before your lordship is that they had put in undoubtedly 30 years of service by now, 28, 29 years, these two SC/ST candidates since 94, 95. We came up with 3 proposals. Your lordship gave a specific direction with regard to the date of regularization, you come ahead with a settlement. So we first suggested to them, we came up with 3 proposals. They did not accept it. They only said that you take, they are telling you now 5 lakhs, 3 lakhs, you go and take it. We have 10 more years of service to render. We are 49, we have 11 more years of service to render. Every month, the regular payment, if it comes to around 50,000 per month, that is the class 4 submenial staff, which the bank employees are receiving and paying. So what we suggested that you kindly regularize your services. If with 2008, your lordships kept that they have a right of consideration for regularization as per the 2 judgments, already order passed by your lordships. That your lordship has already recorded. Now, we said that either you regularize us from 2012, you give us the financial benefit, you regularize us, but give us the financial benefit for 2012. We will forego those past years, we will not press for. Otherwise, there were 2 sanctioned posts of sweeper which fell vacant and we came into that. We are continued as sweeper since 2015. So therefore, the second proposal was to kindly give us regularization, make us regularize us from 2015 and you give us the benefit, financial benefit, because we have got 11 years of service. Third proposal we also came forward, which they have not accepted any 3. They were reluctant to see also that we have filed the present rate application for regularization again in the year 2020. So since 2020, you give us our make us regular just with effect from 2020 and give us our benefit, financial benefit, pass for 6 years financial benefit and regularizer service in 10 to 11 years of service we have to go. So these are the basic things of settlement which we came forward and as per your lordships.
So they did not give any proposal.
So what my learned senior submits that these are wages, so it is not a fact.
No,
your lordship may kindly have a glance
not given anything. They have not given anything.
Mr. Mishra is saying,
my lord,
there was no other proposal from your side.
No, they have not given anything.
Yes, my lord, I have sent it by email.
At the time of sitting,
this is my lords. This is my learned senior should not submit. Yes, I am sharing a copy with them.
Instructed he will answer.
Yes, my lord. Yes, I am giving a copy. These are 3 email has been sent on 19th. Your lordship may kindly have kindly have a glance, my lords. This is, your lordship will see to the CGN, we have given a proposal. Your lordship's order is the first order is your lordship's order.
Where is the proposal? Tell me, sir. I'll just look into that because I have to check up.
No, not check up. We have mailed it on 19th because you gave us only 1 day time.
So
this is the proposal. You should kindly see page 12. This is our first proposal which you are given. Page 12.
Page 12.
100.
Page number?
Page 21.
Page 12. Your lordship will see, pursuant to the direction for amicable settlement passed by the Honorable High Court, by order dated 18/5/2026 passed in WA number so and so, in our considered view, the parties shall sit under the shadow of a tree and explore the possibility of an amicable settlement on the following lines. They shall decide as to the effective date of regularization of services and the grant of service and financial benefits on that basis. The grant of bonus for the period after 2022, if already bonus was granted to the employees during the period between 2006 and 2002. Parties to come back to the court, hopefully with settlement, we make it clear that in the event when no settlement is arrived at on the next date, matter will be heard on merits. So the first, my lords, this is our first proposal is regularization, your lordship, next page. This is the in view of the direction, aforesaid direction passed by the Honorable High Court of Orissa by its order dated 18/5/2025 in writ appeal number so and so and so and so, we
submit the following proposals as follows. Regularization of the appellants Mayadar Naik and Baino Naik from the year 2012 as class 4 employees of the State Bank of India with financial and consequential service benefit under any office of the State Bank of India. Right of bonus, we are entitled for area of bonus from the year 2022 till 2025 to be paid by the bank. The reason for the settlement also we have given. In view of the bank stand in the preliminary counter affidavit filed by the bank in WPC number 24692 of 2012. This is the writ against which we have come out writ appeal. With regard to bonus, it has been specifically admitted by the bank that we appellants were paid bonus for the financial year 2011-12 while bankers check as per para 3 of the counter affidavit filed by the bank. And this read with the specific direction in OJC number 13193 of 99 by the Honorable High Court by the order dated 5/12/2008, wherein the Honorable High Court has disposed of the OJC on 13193 of 99 read with the direction passed by the Honorable High Court in WPC number 8906 of 2007 and made it clear that our case shall be considered for regularization if any vacancies arises in the future. And the bank has ignored the vacancies which took place in the State Bank of India in the other branches of Orissa, branches from the year 2008 onwards. So whatever vacancy fell vacant, they ignored it. It is therefore requested that taking into light our long-standing service in the State Bank of India, Government Treasury Branch, Bhubaneswar, we should be regularized with service as class 4 submenial substaff employees under any office of State Bank of India, Bhubaneswar, as it is prudent to state here that before your good office, that by the time we have filed WPC number 24692 of 2012 for bonus, we had rendered more than 18 years of long-standing service by then. Therefore, our right for regularization accrues from the year 2012 with all financial and consequential service benefit. This is proposal number 1. The second proposal, which is as follows, next page your lordship will see, in view, then same thing, regularization of the appellant Mayadar Naik and Baino Naik from the year 2015 as class 4 submenial staff of State Bank of India in view of clear vacancies of 2 posts of sweeper after retirement of Rabindra Kochayat and another existing vacancy after the death of R.K. Mukhi with all financial and consequential service benefits under any office of State Bank of India, Bhubaneswar. So this is the proposal which I have given for 2015.
Slowly. You are agreeing. If you read like that, we will pretend that we are hearing you. But in fact, we will not be.
Oh, I'll slow.
Yeah. So argue well and well. We have read everything now. What is used in reading? You are here to argue.
So in fact,
regular, please, let me finish.
Just a minute, sir. I'll submit all code. So this document is filed 1906. They gave this proposal. So 1906-11:30, the meeting was held. This letter shows it's 1906. If Lordship looks at 23rd, they are given mail. Kindly have a look at this. They have taken note of the fact about the 1906 meeting.
1906, even we mailed them. Please wait. We have mailed them. Therefore, my lords, 1906, they called us. They did not accept our proposal. Therefore, we have mailed them. We have mailed them and also given them an option that kindly call us before reopening on 21st, which is not the mail now. This proposal. Let me place my proposal. The proposal
was never given by them. As per the order, we requested them to give proposal.
Complete false fact, my lord. They state away told us you take 3 lakhs and go. They state that you come here, sit down, the video conferencing will show, my lords. They have recorded it also. They are not. I am not submitting anything beyond the record.
See the mail that has been given on 23rd. They have attended on 1906. So we said that you give your signature in fact on those that you have appeared for us. They said, no, we are not going to give any attendance.
No, my lords. We have fully cooperated. Your lordship will see that there is no question. This is a kind of delay. The question is, my lord, very simple, my lords. I am putting forth 3 proposals before your lordship that 2015. Let me, your lordship, kindly read the proposal.
Because we can
That they have put in long and spotless service.
Yes, they are there since 95, they are there.
So
But there was,
fact is not in this.
because of the interim order passed by the Honorable Court. And final order has been passed subsequently.
Yes. In one matter which my brother and other brother together decided, they have awarded a lump sum of 15 lakh each.
15 lakhs each. But
The one yardstick. It is not that
I understand.
that it may be little more or it may be little less, depending upon various points, including non-disturbance by the
I understand.
items. So the judgment which you now say,
Sir, I have given a copy.
Just we'll look into whether facts are matchable.
Yes, facts are.
Share a copy with your friend also.
Yes, yes, ma'am. I'll give a copy. It's a State Bank of India versus Shamsundar Adhikari.
What are the foundational facts of that case?
Foundation fact is long history. Since 84, actually, they are serving in the bank.
1984.
84. And the settlement was made in 15/2/1985. The matter went to the tribunal. Industrial Tribunal passed an award. The award was the subject matter of challenge. And eventually it went to the Supreme Court. And they were temporary messengers.
Here we have put in service. Then the respondent worked only for 911 days, the last concluding. The basis for compensation, the respondent worked for a period of 911 days with breaks in service from 1/1/96 to 13/9/2002. Only they have put in 911 days of service. Temporary messengers, which, and the bank came up with a statement that there were 55 persons, but actually the Honorable Court found that there were only 10 employees. And
no, even thereafter, next sentence you did not read. You read only one sentence which appears to be favorable to you.
Well, thereafter, no work has been taken from the respondent.
No.
That is
thereafter, he worked under interim directions of the court.
Those in the
year 2010.
Thereafter, no work.
Thereafter, no work. Therefore, they worked only for 911 days. That is as in September 2002. Thereafter, 8 more years they have worked.
Okay, because they had retired. They had only 1 year of service to go. That is also the fact, which also emanates from the efforts to give the industrial dispute was for 21 years. The ultimate award was dated and thereafter law has changed. Your Lordship has 2023. Subsequently, my lords, 2024-25, your lordship, all the decisions have come thereafter. For such of the person who had crossed the age of superannuation, the bank was directed to pay a compensation of full age.
Mr. Mishra, the apex court says this order has been made under Article 142.
142.
Therefore, that cannot be given as a precedent.
So I don't say that. I say it's a settlement was done there in the bank, the State Bank of India, and the person who was working since 1984, they are claiming right. Tribunal granted them the relief of reinstatement with back wages. That was the subject matter challenge for the High Court. But we say this because number of cases are pending. In the present case also, number of cases are pending who are not satisfied with the settlement made in way back in 1988-89.
No, we don't have any settlement out here. There is no record, no averment. It is only in the national. There is no single averment to that extent with regard to settlement, my lords. Here, all the settlement expired in 97, and that settlement was taken care of by the division bench then. And thereafter, they considered this counter, that is res judicata, barred by res judicata. In the memo under part 2, your lordship will see that there in paragraph 5, all the settlements were discussed way back in 97, at page number 36 of the memo. And subsequently, those settlements were taken care of, and it has expired since 97. And
let us see the orders dated 24/7/2007 and 5/12/2008. These are orders which you have suffered at the hands of the court.
Well.
Let me see these two orders, how they are structured.
2000, your lordship?
24/7/2007, 5/12/2008.
Nice.
The earlier writ application order narrative.
Yes. These are the two orders.
This is your claim. The man corner at the corner of the court. Ask him to sit down.
These are the two orders. I have given that. But again, this is 8906 for your lordships. Again, I am submitting it for your convenience. These are all decided earlier, taken into consideration in the counter application.
Let us see 24/7/2007 order.
Well, I have given that.
These are the orders.
Yes. One is 24/7/2007 order. 2 copies I have given. And the other.
She got it, Manoj? Yes. Okay. So hard not a come. Can I read it?
No.
The last one. Looking at the
nature of prayer and the grievance made in the writ application, we dispose of the writ application with a direction to the opposite party to consider the case of the petitioner in the event they are going to make any appointment to the post of sweeper.
Whether eventually any appointment?
No, sir.
Looking at the list.
2 posts fell vacant, that was abolished because now they have given to outsourcing, no post is there.
They were
With due
interested-
respect, they were not engaged in any substantive post, nor any post is available.
No, substantive, that I.
But if that would have been so, we would have
No, we'll take
them there actually.
Let me
We cannot disregard the Honorable Court's order.
looking at the length of engagement and the service rendered by the petitioners under the badge. So here, madam, what
Fully.
madam, hard learned counsel for the petitioners.
Yeah.
The
No,
gra-
kindly come to operative portion of the order.
looking at the nature of prayer, but first background is that according to the learned counsel for the petitioners, the opposite parties are now going to recruit candidates for 7 posts of menial staff, which include canteen boys and sweepers. Looking at the nature of prayer.
It was your submission.
Yes.
Not submission of the bank.
That is our submission. That time.
What the court said is.
This, looking at the nature of prayer, and well, we had filed 2 writ applications. One was filed in the year 1999. That was with regard to regularization of service. And the second writ application was filed that during the pendency of this, that they were going to outsource others and they were not going to consider our case. We were continuing. So we prayed that in the event you are making any appointment, as per the State Bank of India, that there is a panel which is maintained. Once the panel gets exhausted, this is after 97, if you have put in 5 years of service, you should take into consideration our length of service, and thereafter you should give us an opportunity to compete with the other candidates and regularize our services, because you are going to outsource the persons. And the nature of work is same, perennial in nature, and therefore they should not have come forward with outsourcing. So they went ahead with outsourcing. This, therefore, taking into consideration our submission, this your lordships directed, looking at the nature of the prayer and the grievance made in the writ petition, we dispose of this writ petition with a direction to the opposite parties to consider the case of the petitioners in the event they are going to make
the event.
In the event. That is correct, madam.
So it is
It was in 2007. In case they go for any appointment, we should go.
They did not go for appointment.
They did not go for any appointment.
Therefore, you cannot bank much upon it.
But that is one part. The second order is OGC number 13193 of 1999. Your Lordship, that order I have given.
The Lordship you have given.
OGC number. We.
5/12/2008.
5/12/2008.
We make it.
So let me please. It is my case. Order 18 is very clear. Hard in 5/12/2008. In view of our order dated 24/7/2007, passed in WPC Lordship. 8906 of 2007, no further order is required to be passed in this case. We dispose of the writ petition application in terms of our order dated 24/7/2007, passed in the aforesaid writ application. We make it clear that the case of the petitioner shall be considered for regularization if any vacancies arise.
If any.
I am let me place of case. Please.
Omitting that.
No. I am not omitting. I am reading it. Interpretation.
If any vacancy arises.
If any vacancies arises in the future, so long the work is available, the petitioner shall be allowed to continue to work and as such, and shall not be substituted by any.
Right. You have not brought your efficient junior. See, kindly come to the text of the last paragraph in the order.
My lord.
We make it clear that the case of the petitioner shall be considered for regularization if any vacancy arises future and so long the work is available, the petitioner shall be allowed to continue
as such and shall not be substituted by any fresh hand. The petitioner shall be paid remuneration. That already wages under the minimum, because we were not paid the minimum wages. We had also made our grievance that we should be paid the minimum wages, for which the arrear was paid, and we came forward in the year 2012 that claiming for the temporary benefits that all the the temporary workmen, there were around at least 30 to 40% were continuing. They are getting one slab of pay. We were getting different slab of pay. What they were giving us, my lords, that is a consolidated sweeping charges. So one page I will take the wage receipt. The receipt which they are saying wage, it is a consolidated pay.
Of which year?
Of all the years I had given.
Which year?
My lord, page 15. Lordship have a kindly glance.
So the payment is made the daily basis.
No, please, my lord, it's trying to clarify each and every point. He is having his own interpretation. He is having his
We are patiently hearing.
Yes, my lord. His own interpretation that, my lord, our entire life is at stake.
We are asking one small question.
My lord.
Whether the payments were made.
One, your lordship may kindly have a glance at 1274 WA writ appeal. My lord.
You are not. You are too much identifying with you are standing in the shoes of your client.
My lord.
That's not the job of the lawyer. A lawyer is an independent entity. He is not the mouthpiece of a litigant. Sir, kindly see. What we are asking you, when that payment of amount was made.
This is in the year October 2012, 31/10/2012. The other old REIT records will show that 94, 95, all those what we were receiving. There they are saying, your lordship, can you have a glance at page 50? Can your lordship take to page 50 in REIT appeal number 1274?
Yeah.
The records have given, all the records.
Received rupees 8122.
Branch towards the temporary sweeping charges. They are giving me a pay consolidate at the rate of 262, and that is recommended for payment is 8,122. So like this, my lords, they were granting me temporary sweeping charges. These are temporary sweeping charges. So the question here was, my lords, that these temporary sweeping charges was not in consonance with what the temporary employees were actually receiving, because they took the aid of.
Do not know all that. There is an order of the court.
The order of the court.
Kindly see the order.
Yes, my lords. In the year.
It speaks of minimum wages.
My lords, I will just clarify that. What happened, my lords? We were not paid the actual wages. We were paid less than the minimum wages. So we paid a submission before the court that we are being exploited. Even we are
Therefore,
not.
Court made this order.
Therefore, the court passed this order that they should be paid the minimum wages.
Therefore, your rights are concluded.
Rights were concluded at that point of time. Then when we were exploited further, they did not give us. Then we came in the year 2012 for challenging that we should be paid the temporary benefits. Would your lordship kindly see the prayer which I have made in this writ, that is writ petition number 24692 of 2012. So after 4 years, we wanted to change that all others are paid this because they are taking the advantage of the order passed by this honorable court that we should be paid at the rate of minimum wages. Even that is not being paid. So kindly give us our temporary benefit. So that was the writ which was sub judice before your lordships. That your lordship may kindly see the prayer of that writ petition which I have filed.
You are appearing for bank.
Yes, my friend is here.
So your lordship may kindly come to the writ petition which I have annexed.
Kindly be seated. Let him come. But
the writ petition prayer that will page 47. The petitioner therefore most respectfully prays your lordships will be graciously pleased to admit this writ application. The opposite party shall not, as to why, the opposite party shall not provide all the temporary benefits, including the temporary pay to the petitioners, as provided to the temporary employee, sub-staff, menial staff of the SBI, and denial of such temporary benefit to the petitioner shall not be declared as illegal, arbitrary, and discriminatory, and violates Article 14 and 16 of the Constitution of India. The opposite party shall not be directed to immediately release the bonus to the petitioners for the financial year 2011-12, which they are entitled to, more so in view of the fact that the opposite parties have earlier released the bonus for the past financial years. The opposite parties shall not be directed to release all the arrears of the temporary pay retrospectively from the date of the petitioners are legally entitled to, along with interest, and take steps in filling up regular vacant posts of sweeper subordinate staff under the opposite parties. So when we came to the 2012, they did not pay, my lords, your lordship has made a note earlier a note has been prepared, your Lordship has dealt with it. Your Lordship has seen that since they were not paid the minimum wages, we came before your Lordship and they paid the minimum wages arrears. That also I have annexed and brought it to your Lordship's notice. Your Lordship's notice. They are in that preliminary. Let me finish my argument.
No. They have paid. There's an admitted fact. We have paid the differential amount to them by check. They have accepted it.
Yes. So your Lordship kindly are paid.
No, actually, what is it? That minimum wages have been going on paying. There was a change of minimum wage.
No.
So the
that is not this fact.
Just a differential amount
they were not
calculated, then differential amount has been paid.
Your Lordship may kindly have a glance at page 158. Can your Lordship kindly come to page 158 for a moment? In 158. 158. That's list which we have furnished. Our serial number, your Lordship will see our name at serial number 19. Okay? That we are working since 1995. All these persons were working as temporary workers. They were not permanent. These are all submenial, substaff, temporary persons working under the bank. The lease was furnished in the year 2001. Okay. That was maintained by them. So that record will itself clarify that serial number 20 is petitioner number 2, page 159. Your Lordship may kindly have a glance. We are working since 95 and all these persons, they had filed writ petitions before the court. Different writ petitions numbers have been given in column for reason for continuance, which they have added. Reason for continuance is various writ petitions were filed during that period. Some were disposed of, some were continuing. So admitted fact, this Vichitrananda Mahapatra, Trailokya Mahanti, these persons' names also I have given in the discrimination part under Article 14 that they were getting a higher pay, which were that your Lordship may kindly see serial number 26. Trailokya Mahanti, 32 Surendranath Das, 1 Purnachandra Sahu. That Purnachandra Sahu also at serial number 37. His slip also I have given. From the bank we could manage to get his.
Now, what is your prayer before us?
That time our prayer was my Lord.
Not that time. Now prayer is what?
My Lord's twofold prayer is there.
First prayer is
with regard to the old 2012 writ. That is with regard to our temporary arrears which others have got, which we have not got. The temporary.
Now, how can that be? You have got an order which directs payment of minimum wages.
Correct. Your Lordship is correct. That order, to get over that order, we came up before your Lordship only in the year 2012.
How can you get over?
Because my Lord, your Lordship will direct, but that it cannot. Bank has its own terms of payment, so it cannot be a perpetuity order that it will continue till my retirement. Suppose I work till 60 years, I will be only getting minimum wages.
Because you have got that order.
Because no, that order was that time was there. So to clarify that order, to get over that order, not get over. To say that we are entitled for the temporary benefits which other workmen, suppose.
That contention was available to you.
When, my Lord? No, that time,
when you
that time, whenever we work, during that particular time, that was in the year 1999. Okay. So 2007, the rate was disposed of. In the year 2008, one is with regard to appointment, the other rate was with regard to the year 99. There, your Lordship will come up with a counter affidavit which they had filed in the petition in the memo which I have given. Your Lordship, their counter affidavit in the year 99, that old rate, which counter affidavit I have brought it up on record before your Lordship. Your Lordship may kindly come to the memo. There I will clarify it. That stand. That memo is there before your Lordship. Wherein there in the counter affidavit.
Now, how are you going to come over this res judicata?
No, that is not, my lords, that is not a res judicata. My submission is that once there has to be parity in pay scale. So the High Court
ground available.
My lords, the High Court can grant no wrong relief. Well, rightly or wrong, the High Court, in their wisdom, at that time they thought it prudent that since we were exploited, that is my contention before your Lordship. So therefore, I should have been granted the temporary benefit. That is one aspect. But they did not grant me that relief. So your lordship may kindly have come to their counter affidavit, which counter affidavit, because they have not brought it up on record. That the problem is, whereas I have brought it up on record, the 99 counter affidavit your lordship may kindly see.
99 affidavit.
99 affidavit.
Why we should see that?
That for the purpose, they filed in that affidavit with regard to all these two matters are conjointly taken up and disposed of together. The regularization matter as well as the temporary benefit. So in the regularization matter,
in temporary benefit matter,
because they have taken up that, so therefore that record I have brought it up on memo. In temporary benefit,
you do not understand. Perhaps we are not able to convince you. Anyway, we need not convince you for writing. But you have to convince us to write a judgment.
Yes.
We will not convince the lawyers at all.
Your lordship may kindly.
We'll go methodically.
Well,
we have been taught some principles in the law school. Let us apply them here. First one is, what was your prayer in the two petitions?
8306 and yes. In 8906, my prayer was for regularization of our services.
That was not granted. They only say consider them.
No,
in the event when a vacancy.
Your lordship said,
Mr. No, we have
to assist your lordship. So kindly see this date chart. What is your lordship's assistance?
5/2008 order.
Well,
that only prints the order dated 24/7/2007. They go one step further.
They say that
no further order is required.
No further order is required to be passed in WPC number. No, in this case, because this is for regularization. But they dealt with the issue of regularization in the next paragraph. Can I pray the substantive portion is this?
What we suggest is,
we make it clear that the case of the petitioner shall be considered for regularization if any vacancies arises in the future. What happened, my lord? State Bank of India, Odisha has number of branches, around 30 to 40 branches is operating in the state. So from 2008, our right emanates that the post which fell vacant, they should have considered us in the vacancy post, which they did not consider us. They continued us. They continued us. That was an order which I, in terms of Hon'Ble, I will say that it is not a continuous order. It is a conditional order that if you work, then your services will not be dispensed with. So it was left to the authorities to take a decision on my working or no working. They could have retrenched me at that point of time, following 25F or whatever, but they continued me after that period. We continued and they went on continuing. In between, what happened, my lords, when we came up before your lordships in this court, there was an interim order passed by this honorable court in WPC, in the OGC for right of regularization, this case, OGC number, in WPC number, this 15989 of 2020, there was also an interim order that if a representation is pending before we have given it to the chairman, that should be disposed of by the chairman. What happened, my lord? The chairman did not deal with it because the right of regularization, the chairman is to take a decision, the bank highest authority. The AGM took a decision and he rejected the contention. He said that your representation is rejected, for which I filed a contempt. That contempt is sub judice, but that was not taken up in this conjugate appeal. These two writ petitions were decided, but the contempt was left. That whether the AGM has the right to reject our representation when the actual authority is the chairman, so he has committed a contempt of court. During this pendency, my lord, the hearing was done. This honorable court also asked in the learned single judge, that how many persons are working in your bank? What are the temporary persons who are working? What is their pay? What is your pay? They did not file that. They left the incongruity was maintained by them. They did not clear that how much they were paid, how much we were paid. So that the decision could have been taken with regard to my temporary benefits. And so far as the right of regularization is concerned, my lords, this regularization right, so far as 99 was concerned, my lord, we were governed under the Parasin's judgment in 1992 Supreme Court, where they said that those who have continued for 5 years of service, they would be entitled for a regularization. That time, the judgment was there.
That was there when these two writ petitions were decided.
When this writ petition was decided.
Yeah, but you have suffered this order. Or you have enjoyed this order. You have enjoyed or suffered, depending upon your perception.
My lord, that I cannot say any, I cannot have any qualms over that.
Yes.
These two orders which came up,
They see your
on
fate.
that time also they said that no, we will consider their case for regularization when you fill up the vacancies.
Yeah.
What they did not fill up the vacancy, they went on a person of outsourcing.
Yeah.
Which has now been deprecated in Jago. Your lordship has dealt with the judgment that outsourcing, long-standing outsourcing cannot form a solution for this basis, those who are continuing on perennial and permanent basis.
What we are just thinking of is, it's a case where the secondary relief should be granted. Compensation should be granted. You just ask your friends who are present before the court, are they agreeable for
if your lordships come forward with a compensation, I have given a proposal, 3 proposals. I have got 49 years now, I have got 11 years of service to go. Regular service period is there. So far as the back period is concerned, if that artificial discrimination is concerned, some period should be given to me as the
you quantify your prayer in terms
because
of
if
money.
the calculation is, if
How much
the temporary was 25 lakhs to 30 lakhs, it is coming. Temporary benefits. Temporary stay. Regularization for 11 years, it will come to around, my lord, so let us say it will be around 7 lakhs per annum or 11 into 7. That comes to around 77 lakhs if I would be allowed to. But so far as the present, because there is an annual increment every yearly, there are annual increment variables and other things are concerned. So it comes to around 77 lakhs.
Your proposal should be in such a way that if you want the benefit which you will get in the event you succeed in your petition with full prayer, it should be less than the actual payment we are just contemplating. See, what is that amicable settlement? Mr. Ratho will walk a mile, and Mishra also has to walk a mile. Maybe little distance will be this side, that side. That is amicable settlement. If you are going to calculate that way, what will happen to these orders?
My lord,
rightly or wrongly, they may not be very happily worded.
No, my lord, so far as regularization is concerned, we have a right of regularization. It emanates if you have long-standing service. Since we have filed the writ way back in 1999, and that was kept pending like that, we came up in the year for 2012. Yeah. So that particular should be, a cutoff date should be arrived at. My lord, my submission is a cutoff date should be arrived at. If we are regularized from 2012 with all financial benefits, my lords, then it comes to one amount. Now, your lordship, why I was taking to the counter? Because there were 2 regular sanctioned posts of sweeper in this particular branch, which fell vacant in the year 2015. We were working as on consolidated temporary sweeping charges we were receiving. Thereafter, we continued full-fledged to work from 2015. That is in the counter epidemic.
There is one English film, For Your Eyes Only. Do you know? It's like that, no? Only for your eyes. See that.
Led by Sean Connery. Sean Connery also.
Don't utter anything. Just have it in your mind. All right. Give that to. You pass it on. Give it to. Give it to.
Your Lordship, may kindly have.
Yeah. What's your response? You are standing like a sphinx, but we cannot work out what is happening in the mind of sphinx. We'll come to you.
I cannot independently commit anything. His Lordship knows, my lord. What Your Lordship indicated.
Because you are appealing for a statutory.
Right.
If you were to be here, of course, you were not cursed to be here. What do you feel about that figure? We are not disclosing it to anybody.
Can I write something, my lord?
Yes. Give it to sir.
Okay, it is.
Litigation has to come to an end. Unless litigants want to enjoy the very process of litigation itself. There are some countries, I will not name them, which go on fighting endlessly, unmindful of the benefit, curse, loss. Always our expectations are very high. Human expectations are very high.
For your Lordship's workshop in the mind, it is working out. Just one paragraph, can your Lordship read?
We'll read only one paragraph. We'll read several paragraphs. Whole day we'll hear. Only thing is, you have to have some protection after you leave the court because your friends are waiting. They are waiting in militant silence.
Very personal. I have not talked to the client.
No, understood. Understood. Do you want to write anything?
Can I take assistance of my?
The litigants are here.
Can I ask them? Can I put a question to suggestion to them?
Yes, you ask them. So that, see, there are arguable points on either side. You are a strong advocate. Mishra is also a strong advocate. But unfortunately, we have one weak judge out of the two. Therefore, that risk, weakness of a judge is a risk to which litigant we don't know, this side or that side. Therefore, fighting legal battle on cocksure ground is far better because you do not know what we are going to do. And fighting appeal against an adverse order in the event we make one at Delhi will not be that desirable. It is avoidable. Therefore, I very often quote the idea of justice by Amartya Sen, which he wrote in contradistinction to John Rawls' A Theory of Justice. Yes, then we have some points. You will know what Amartya Sen has said, great thinker, a famous book for which he was awarded Nobel Prize, Idea of Justice. So beautifully he has said it. Our expectations are very high in courthouse. Both the sides think that they will succeed. Very impossible it is. Therefore, we have to modulate our expectations and desires consistent with hard realities of life. You can't ask something which will be a bolt from the blue to the bank. Bank should not think that it should close its shutters. At the same time, bank cannot think that some frugal thing will throw like a slice of bread to the dog because they are human beings.
Right.
Therefore, between these two extremes, some golden balance has to be struck. For that, we need your assistance. You are not just lawyers. Lawyers does not mean that you are the mouthpieces of your clients. You have independent version. Law officers of the court you are. Therefore, keeping all principles, this res judicata, that judicata, everything. What is the possibility of winning in this battle? Therefore, our Smritikara say, Vinashakale samutpanne ardham tejita panditaha. When everything is being lost, one who saves half, he is pandit, a learned man. This applies to both of you. It applies to both of you. Suppose if we make an adverse order, it will be great hardship to you because individually you have to fight. They are an institution. If we make an order against their interest, they are bound to fight it up to the apex level. And once it is stayed, you know what will happen. So keeping all this in your mind, we call lawyers as counsel. Is it counsel? Why counsel? That word you will not find in the Advocates Act. But in practice we do because you are counsel because you are not only advocating here. You advise your client also. You counsel them. Maybe to the judges also you will counsel. Therefore, just have these things and view our proposal.
My humble submission is one thing, and also keep note of fact. Because of, say, corporate sector, I have to tell that in spite of outsourcing, though outsourcing people are doing their own, because a tender floated and outsourcing people came and they do the work, still then these persons are retained and paid their wages.
No, you are paying only
they are being paid their money, and these persons are also paid. It's a double payment, in fact, but we paid. And the wages update, rise of wages has been paid, not that till the day of their completion.
If both of you permit, the brother will speak to the litigants in the colloquial.
Yes, yes.
If you permit,
why not?
Your clients are here.
Why not?
If you permit, we will interact with your clients.
Yes, yes, my lord.
Without your permission, we will not do.
Why not, my lord?
Before your lordship says that, something works out in your lordship's mind which your lordship is going to express. Your lordship may kindly keep it in note that last we were drawing is 16,406. 16,406 was our last payment, which they were the other employees like Gajendranath, Vichitranath Mahapatra and Toiloka Mahanti, that list which I have given, they were receiving 27,445. That is on record at page 155.
Since how long they have been received?
Since periodically since 1995.
But why you did not press that ground in the earlier writ petition?
But the question is, my lords, as your lordship is aware, one thing I would like to put, that there cannot be any res judicata in pension, because that is a continuous cause of action which goes on, which my learned senior is placing it. Because every time there is a pay revision, pay scale comes up, that we are entitled to.
No, that you are not.
But our fate cannot be sealed in the year 2000.
You can seek revision of
that order.
Minimum wages based upon the notification to be issued by the government, the wage board under section 4 and 6 of the Minimum Wages Act 1948. 46 or 48.
It revises every 6 months.
Your lordship, kindly 3 pages, your lordship will see. This particular question which your lordship is putting to me, the answer is my learned senior said that there was some revision of wages. Therefore, that area was paid, which is not a fact. Why? Your lordship may kindly have a glance at page 160 of this petition. That itself, the pack of cards, it will form the entire argument.
Which year? That means, can we take that you are not agreeable to our proposal?
No, I am.
You're agreeable?
Agreeable, but your lordship kindly but I am having few suggestions to work out a better proposal which your lordship will come forward. That is my sole endeavor. Otherwise,
better in the sense, in one that you have seen, or
that one which your lordship has proposed, bit better than that. I would like to show it to your lordships, because the illegality committed upon me, if your lordship feels that, if there is some illegality committed towards me, your lordship has come forward with a proposal, which is there in my mind. Now your lordship is going to disclose. But prior to that, 3 papers I will take your lordships. One is page 160 of this petition. This is W Appeal 1274. Your lordship will see. This was paid to us. Your lordship got it.
28,875.
Yes, my lords. That your lordship kindly see the date. That is very vital.
That was 12 February 2009.
February 2009. So our order came in the year 2008. So we were
December 2008.
2008. So therefore, after that period, since the
from December 2008 to February 2009. What is the gap?
Within the period, that time that was 30 rupees. In the year 95, it was 25 rupees, 30 rupees. This was the wages we were receiving, not now which people are receiving, that minimum wages. So 30 rupees, that differential amount from 95 till 2008 was 28,875. This differential amount was less than the minimum wages. My contention before your lordship is that why I insisted for the minimum wages, because we were even not paid the minimum wages. So therefore, this honorable court directed that, and that if they don't obey it, it will be a contempt of court. That is why the reason they paid me the area. They themselves, the bank themselves have calculated it. So all these wages are 30 rupees, 50 rupees, 40 rupees, like that, the wages, which the differential amount. In a year, that comes to around, for last 15 to 20 years, which I had put in service. In the year 2008, I had put in, my lords, 94, around 14 years of service. That comes to around 28. So this is the discrimination part, was one thing. And another aspect, just another point, my lords, page 45 of my memo, your lordship will see, in the counter affidavit which they have given. Paragraph 5, only that your lordship will see. That is filed in the year 1999. Your lordship will see that all these things which have taken, these things are barred by res judicata. They cannot be allowed to raise any further in any writ petition, because that is settled. Once settled, stare decisis comes into play. Your lordship will see paragraph 5, that in reply to the averments made in paragraph 3 of the mispetition, it is deponent humbly submits, as this honorable court initially passed an interim order not to restrain the petitioner if there is work, the opposite parties in their wisdom thought it prudent not to discharge the petitioner. Your lordship may kindly see. Yes. Your Lordship got it, na? The opposite parties, in their wisdom, thought it prudent not to discharge the petitioner, even though they were surplus staff in the branch, as in the meantime, 2 permanent sweepers have been posted in the branch, and there is no availability of work. This deponent humbly submits that the petitioner cannot take advantage of the situation and submit that in their excess work, and the work of the petitioner is perilous in nature, and etc. There they say the submission of the petitioner Annex 7 category also that there exists huge amount of work is submits. That the branch manager said that 2,000 square feet has come up, so you require surplus employees. We require additional post. Submit that even after issue of letter of 7, in addition to the permanent sweeper of the branch, namely R.K. Mukhi, the management of the bank have posted another sweeper, namely R. Gochayat, in the branch, transferring him from the Puri branch of the bank, where he was found surplus. They said R. Gochayat has joined on the branch on 6/10/99, and there is absolutely no work available. So,
what was his status there?
That time he was a surplus staff. That is what they are saying.
Plus status. But
He was
his status.
Temporary status, temporary.
But here temporary, again, the manner in which they have been engaged here.
because that they have not reflected it, and neither we can.
That means he was
Even if you are therefore, even if you are a permanent staff, the question is in the year 99 they are talking about, and those 2 posts fell vacant in the year 2015. So therefore, against these 2 sanctioned posts also we are continuing. So therefore, our right could have accrued also from 2015, if not from 2012. And thereafter, I gave the proposal in the year 2020, since nothing came up.
There should be some limit for every case. Can we go on like this? What will you?
That much only I wanted. That much I wanted to point out. So according to my lords, that is all. Can I, my lords, call them?
Yeah, you put you just interact.
My lord.
Contempt, just ask.
Your lordship, whatever your lordship has expressed, that I will tell them.
Yes.
Can I? Yes.
1 second. If you permit,
no. That must not see.
Yeah.
ये जो रेगुलराइजेशन मैटर नहीं करी जो कंप्रोमाइज हवा पे जाउतले बाकी कन्सलेशन हवा पे जाउतले कोन मंडा नहीं जाउतले कोन हितले हिता केते पैसा पैसले हिता
तो 94% कोई सारे लिखी दी तो ଭଲ ଯେମିତି ମିଳିବ ପରିବାର
କେତେ କେତେ ଏକ୍ସପେକ୍ଟ ଆଜ୍ଞା
ମୁଁ ଯାହା କରିବି
ନାଇଁ ନାଇଁ ଆପଣ ଯାଇଥିଲେ
ଇଚ୍ଛା କରିଦେବା ସାର୍
ଆଜ୍ଞା
ଆପଣଙ୍କ ଇଚ୍ଛାରେ ଯାହା କରିବା
ଏପଟେ
be seated. We are interested.
ସାର୍ ଆପଣଙ୍କ ଇଚ୍ଛାରେ ଯାହା କରିବା
ବ୍ୟାଙ୍କ ତ 5 ଲକ୍ଷ କହୁଥିଲେ ବର୍ତ୍ତମାନ ନାଇଁ ନାଇଁ ଆପଣ କହୁଥିଲେ ନା ଯାହା ଆପଣ କହିବେ ବୋଲି ବ୍ୟାଙ୍କ କହୁଥିଲେ 5 ଲକ୍ଷ ଆପଣ କଣ ପାଞ୍ଚଟା କେତେ ହେବା କଥା ବୋଲି ଆପଣ ପିଛା କେତେ କହୁନା 10 15
20 ଲକ୍ଷ 25 ଲକ୍ଷ
ଏଇଟା କରୁଥିଲେ
ଆଉ ଅଧିକା ଦରକାର
Don't advise when for interacting. A lawyer talking to the litigant is a contempt of court. It's a contempt of
ଆମେ
ଆଜ୍ଞା
30 ଲକ୍ଷ ଟଙ୍କା ଦେଇଦେଲେ ସାର୍ ବାପା
କଣ କହିଲେ ଏବେ ଆପଣ ନିଜେ କଣ କହିଲେ ସେ କଣ କହିଲେ
ସାର୍ ନାଇଁ
ଆପଣ ତାଙ୍କ ସହିତ ଯାଉଛନ୍ତି ତାହେଲେ ଆମେ କାହିଁ ପଚାରିଲୁ ଆମେ ଜାଣିଛୁ ଆପଣଙ୍କ ମାଇଣ୍ଡ କଣ
ଆଜ୍ଞା
20 ଲକ୍ଷ
କହିଲେ କି ନାଇଁ କେତେ କହୁଥିଲେ
ଆଜ୍ଞା
20-25 ଲକ୍ଷ ହେଲେ
20-25 ଲକ୍ଷ ହେଲେ ଆପଣ ହବ ବୋଲି କହୁଥିଲେ କି ନାଇଁ
ଆଜ୍ଞା
They would have no objection if they are given a compensation. When they're
in other words, they're agreeable.
They're agreeable
To receive the compensation.
Receive the compensation.
Correct? What is the amount of compensation, sir?
20 to 25 lakhs.
Okay. We heard this matter for quite long period. Though it did not merit. First time. At long last, we interacted with the litigants personally after taking leave of their advocate. First, ask them to leave the hands. This is not temple. Yes. We got some wisdom from the judgment of the apex court, of course, rendered under Article 142 of the Constitution of India, and therefore we are conscious that it does not have the presidential trappings. First one. In the said judgment, a sum of rupees 5 lakh is awarded as compensatory relief in lieu of regularization and continuation in employment. First one, it's a kind of package. First one, we have borne it in mind. In another more or less similar matter, wherein a scheduled bank was the opposing party, we noticed that a coordinate bench of this court, in which one of us was also there, into brackets, a sum of rupees, a lump sum of rupees 10 lakh has been awarded. First, the bank and the appellants sat for amicable settlement, wherein the bank had offered to pay rupees 5 lakh in a lump sum to put a decent burial to the ongoing litigation. First one. Next one. We interacted with the appellants, or one of us interacted with the appellants who are personally present before the court and in the language known to them. First one, they expressed their willingness. They expressed their desire to settle the dispute once for all if each of them is paid rupees 20-25 lakh in a lump sum. All this is available in the online proceedings of the court. Next one. We have also noticed the two orders, one dated 24/7/2007, entered in appellant's earlier WP number 8906 of 2007, and the other dated 5/12/2008, entered in their OJC number 13193 of 1999. First off, the former in its operative portion reads as under. First one, next one. The latter in its operative portion reads as that. There are next one. There are arguable points from the side of the respondent bank by pressing into service the doctrine of res judicata in terms of the orders which the appellants have procured / suffered at the hands of coordinate benches. First one. Learned counsel appearing for the appellants vehemently submits that in matters like this, the doctrine of res judicata stricto sensu may not be applicable. Be that as it. First, justice of the case in our considered view warrants that no order for regularization of the employees nor their continuation in service be granted. Second, instead, they be awarded compensatory amount by way of final settlement. First term. As already mentioned above, we have noted award of ₹5 lakh by the apex court in the judgment referred to above, wherein the length of service was not even half of what the appellants herein have put in. First term. We have also again noted the award of ₹10 lakh made by the coordinate bench in WPC number 8128 of 2019 between Cooperative Central Bank Limited versus Bhapa Sundar Dalai and another. Disposed of white judgment dated 17/3/2026, authored by one of us, namely, into brackets, last. First, we are also conscious of the sliding down fall of rupee value in the present socio-economic scenario. First off, keeping all relevant factors in our mind, we are of the considered view that the bank should pay a lump sum of ₹20 lakh to each of the appellants within a period of 4 weeks, with a default clause of levy of interest at the rate of 1% per mensum, as has been done in Cooperative Central Bank's matter, and 2% for the first 1 month of delay, and 2% for the period next following. First, next paragraph. We order accordingly, and these two writ appeals having cognate matrix are accordingly disposed of.
Let me indicate one thing, Lord.
Yes.
With due respect, Lord, for the Lordship's consideration, they have been paid 3,30,000 each, which may be
What you have paid is frugal money. In fact, we wanted to award a little higher money, but we just looked into the falls in the
that
bank.
includes, you want that is to be lessened.
This is what we are giving you.
The reason being that
nowadays, the rupee value has gone down.
No, I understand. That was
And bread
recently paid.
has become costlier than blood.
So I don't argue on the quantum. I say the amount of 3 lakhs paid after their service, that should be deducted.
No. The vehement submission of Mr. Learned Senior Advocate Mr. Mishra appearing for the bank.
The terminal benefit of 3,30,000.
The terminal benefit of rupees 3 lakh plus should be taken into account while computing
20 lakhs.
This 20 lakh does not impress us. Does not impress us. Regard being had to the longevity of service put in by the appellants all these years with the minimum wages, when arguably they were entitled to, they could claim the remuneration otherwise payable to the temporary employees.
And this may not be a precedent. There is a standalone case.
Mr. Mishra, very often we come across such submissions. They are very good. But Rupert Cross, in his law, the president in English law writes, the court which is rendering the judgment cannot say whether it has precedential value or not.
No, what
it
I
is
say,
for the other court to decide.
What I say, keeping
another cause.
Keeping in view the peculiar facts and circumstances of the case.
Where other matters are pending here.
Yes.
Since we have structured this judgment more on fact basis,
right.
It hardly needs to be stated that it does not have the precedential elements.
Correct.
Okay, this much.
And that contempt petition they have filed after 9, 10, 15 years, they conduct with the continuation of delay that may be disposed.
No, that is there here.
Yes.
In view of this order, the contempt proceedings stand dropped.
Right.
Stand dropped with the warning that the bank shall comply with the mandate which in time without driving the appellants to another round of legal battle, which certainly would prove to be disastrous to the interest of the bank.
Right.
Yes,
Hello, please.
Yes, possible. Yes.
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 No. Order of the Central Administrative Tribunal under challenge, my lord. Order of the Central Administrative Tribunal under challenge, my lord.
Yeah.
That
Who is your opponent? You are here.
In fact, the question before the tribunal, my lord.
It's for admission or post notice?
It has to be disposed of.
Disposed of.
It's a very short question, my lord.
No, whether it is for admission or for final disposal.
Pleadings have been completed.
Pleadings are complete, my lord.
Pleadings are complete.
Yes, yes. So far,
any urgent matters we have, where interim orders are sought for.
My lord, one item 2 is contained, my lord. In this item of 27, I have not filed the rejoinder, my lord.
You are not filed rejoinder.
Let that matter come some other day, but last matter may be had. Because my
similar, my lord.
The last matter is ready.
You are in the second
all
matter.
respect. I just request you, Lordship, please hear this first matter. And the other matter, let him get ready, my lord.
They are connected, we cannot do that.
Same issue, my lord. Issue is
They are
same.
similar. You want to fight counter?
Rejoinder.
We'll call this matter on 8th. Again, you should not seek time.
No, my lord.
Call this matter on 8th of July. As requested by the net council appearing in a very WP number. Yes. Why everybody is standing like this? Update matters.
Serial culture.
But just which is your
Third. My granted is the
3rd of July. What is that matter? Pension matter. So,
Item number 31, my lords. It's a case, my lords, in 3 read petitions. Two of them were orders that passed by your lordship and one by the vacation bench. The borrowers have admittedly not complied with the orders of this court. So, your lordship, I kindly dismiss them.
That's true, lordship. Item 31, I'm applying that case. Lordship, definitely, lordship will give protection to me. But I'm trying best to comply, lordship. So let it, lordship. Otherwise, lordship is.
once it was given.
So, twice your lordship had given, lords.
The lordship,
If you are not complied with the condition.
No, I have come against lordship. Only demand notice. There is no order against Surface Act or any provision. So if even if dismiss lordship, bank is not getting.
No, it is about physical possession. Your lordship had specifically directed. Your lordship had specifically.
No, I am not saying I go lordship. If lordship is giving time sometime, then I can deposit. Other also I will permit to.
Your lordship specifically granted time.
The charge by the borrower is to the coercive action of recovery of outstanding loan, not put under the provisions of the Surface Act 2002. This court, at the admission stage, had granted interim protection, while order dated so and so, which reads as next paragraph. The borrower was shown indulgence with the hope that he would comply with the condition stipulated in the above interim order, but he failed. First of all, in view of the above, the petition is liable to be rejected, and accordingly it is. Cost having been paid.
Item 28 also. Trade union matter, verification process installed.
Trade union matter. Trade union matters, what is the urgency?
Minority, that the union is not functioning. The workers are not put for their grievance before the management, as because the management has obtained the order of stay. Verification process is going on.
Because this matter in the last week of July 2026. Yes, next week, man. Yes, sir.
My turn 30. Last occasion, directed the Solicitor General to Assistant Solicitor General to seek instruction regarding appointment. So twice they have taken. Now they are not present also. And tomorrow they have to.
7.
I'm here, man. I'm not
36. The same matter may come along with WA number 2168. Both the cases are stated.
Mr. DYSG is there in that matter.
2168.
Which is already there on 7, no?
They are
Online.
Yeah, we have put it to 7.
Yes.
This, Mr. Raut, your matter was in 36, item number.
36.
So you want another writ petition to be taken up along?
WA 2168 of 2020.
Kindly record.
You call along.
2168.
Right, Dr.
WA 2168, item number 36. 2168 of 2020. 2168. 2021. Item number 36. Take number 36.
First to item 28, anything not to be completed. 28.
28.
What to be done? You want time in this matter?
No.
July. Entitlement is there. Wherever entitlement is there, continue. There is.
My lord. Thanks to the last order, my lord.
32, my lord. May it has been alerted to Mr. Khandatra because of medical he has leave. Has they got the instruction that within a week it is to be done, order has to be carried out. So may I pray next
1 week you will
1 week
complaint.
1 week after it will be compliant.
We'll record that one and drop the proceedings with the condition that you will be at liberty to revive it for aggravated contempt.
Yes. Yes, ma'am.
All right.
But I play only if he's saying something, they can be adjourned to next week.
No, that will not help you. Put it to aggravated contempt.
7 days.
So that we'll have no option but to face the contempt.
7 days. 7.
This budget petition alleges non-compliance of order dated
25 to 2026.
26 entered in appeal number.
Appeal 1825 to 24.
Appeal number 1825 of 2024. First of all, the operative portion of the order reads as under. Next one. This court, by the order dated 7/5/2026, has issued emergent police notice with a caution notice. First one, the said order reads as under. Next paragraph. After service of notice, the contemners having put in appearance through the learned DGA, though initially resisted the contempt petition, now submit that the order in question shall be complied with in letter and spirit within an outer limit of 2 weeks. Within 2 weeks in first one. This submission made by Mr. Bonte, learned AGA, consciously, is placed on record. First one. In the above circumstances, this proceeding is dropped with liberty to the complainant to seek its revival for aggravated contempt in the event compliance as undertaken is not reported within is not done and report is not filed in the office of the Registrar General of this court within 1 week next following. First one. Yes.
And cost part also they have not complied. My lord directed to 50,000 cost in absence of compliance of the earlier order. That has also not complied, man. Page 20.
50,000 is not paid.
Not.
My lord, that instruction I don't have them. My lord, that may be reflected in the order.
Exemplary cost.
We also
Page 20.
Note the submission of the net counsel appearing for the complainants that the contemners have not paid the cost of rupees, exemplary cost of rupees 50,000. That became payable on account of non-implementation of the order in question. First off, even this needs to be complied with by them in the above circumstances. Yes, sir. Yes, Mr. Rao.
And but the appellant, as per the other side, wanted an accommodation.
Files. Payments for him taken out day after.
Yes, on 9th of 9th of. At the request of. Yes, sir. Nine.
Interim order to continue.
Interim order. You have interim order?
No, I haven't.
Interim order continues calling the last week of July. Yes. Next. When matter is posted, you don't argue. When we fix the date, you say next week. Yes. Yes. What is this?
This is state of Orissa.
State of Orissa.
Yes, Mr.
Dear my lord, bereft of other facts, my lord, the crux of the point is there is a triple benefit scheme, rule of 1966. It specifically says that the non-government primary school teachers, those who have retired to 1/4/1982,
On or before or after?
exactly, before me,
Before.
1/4/1982, they will be governed under that triple benefit scheme, you know. That scheme is
What is
also, my lord, can have a glance to,
What are those triple benefits? 1, 2, 3.
my lord, that benefit is they will get the benefit so far this pension, they cannot be covered under the 92 rules. Pension rules, my lord. They can get the benefit.
Now, what are the 3 benefits?
Yes, my lord. May I place that rule because that has been annexed, my lord. It will be convenient. It is at Annexer 5 at page 40, my lord.
Agree.
To the counter affidavit filed by the
Very good.
There are 7.1.
yes, my lord.
Whether daughter of deceased employee is entitled to
They will
family
get the-
pension or not,
or not.
the issue.
Exactly.
That's the only issue.
He only is.
On what basis she is entitled to?
The benefit which is claiming by the daughter of the deceased, it was a case which has been agitated after lapse of 21 years, my lord.
When he died.
Exactly. He has died in 27/7/1988.
When compassionate appointment was claimed.
Millard, long after Millard, it was first time being claimed in 9/8/2021 at the age of 75 years.
Of the petitioner.
Yes.
Claimant.
Yes, yes, my lord.
At the age of 75.
Yes, my lord. Millard, before that, two date is very important. That the date of appointment, that is on 11/1/1926.
11/1?
26, my lord.
1926.
Yes, my lord. Date of retirement. Exactly. That is very important. Date of retirement.
But he died in harness.
No, my lord.
No?
31/12/1969. Date of retirement.
He entered service in 1926.
26.
Which date?
11/1.
11/1, my lord.
8/1.
Huh?
8/1.
8/1.
1926 and retired on 31st
31st December 1969 and date of death, my lord.
27/7/88.
Exactly.
Death is?
27th July 1988.
You have said that already.
Yes, ma'am.
Same date.
Yes. The writ application which was preferred, my lord, it was in 2021.
9/8/2021.
Exactly.
No, 9/8 is, you said
Order.
claim was made.
My lord?
Claim was made.
Now, this is the order passed in this writ
Oh,
application.
9/8/21.
Exactly.
And the writ application was filed.
It is in 2021, number 22256 of 2021.
And claim was made before the authority.
Sometimes in 20, my lord.
When it was.
That was
For compassionate appointment.
no compensation.
No, my lord. Pensionary benefit, my
Family
lord.
pension.
Because by that time she was 75 years.
For family pension, where is the age limit?
No, my lord. I'm
Suppose,
submitting.
Brother,
employee
after 80
dies
is there.
after 80 years. Wife will be 75 years old. Widow will be 75 years.
But I'm not disputing, my lord. I'm placing the facts, my lord.
No, but at the most, the arrears may not be granted. But the pension is an accruing new, it's a recurring cause of
That was rejected by the authority.
On what?
Account General, my lord.
On what?
My lord. Page 42 for a moment, my lord.
19 or 42?
No, my lord. Only 42 pages. That I am relying the triple benefit scheme, basing upon which the claim was rejected.
Whether it provides for family pension or not?
Yes, my lord. Rule 15, my lord. At page 42, my lord. 49 page is 42
Not
page.
extending anything.
Notwithstanding anything.
Pension, gratuity,
Should be admissible in chapter.
private fund, etc.
Exactly.
Now, why you are reading that?
Notwithstanding anything contained in these rules, a teacher who by reasons of his being aged more than 30 years on the 1/4/1964 is not entitled to the following concessions,
Correct.
namely
ABCD, their family pension is not included.
ABCD. Pension gratuity would have been admissible in chapter B, have been more than 30 years of age, dated such and such. Gratuity equal to 3% total salary during the entire period of service in lieu of contribution by the state government and the local bodies of this case may be to the provident fund, provided that teacher who will receive such gratuity will not be eligible with effect from 1/4/1964 to the benefit of the contribution by the state government or local bodies, as the case may be, to the provident fund to which he subscribes.
Why are you reading that?
And the next page, Mula. The family of the deceased employee covered under the TBS is entitled to family pension with effect from 1988.
1988
88.
means
As per the notification dated such and such, amendment notification dated such and such, the family of the deceased primary school teacher who was a pensioner under the TBS shall entitled to family pension if the pensioner died on or after 1988.
1988. Well, not 27/7/88.
Exactly.
So if death occurs before 19, no family pension.
Yes. Because they are covered under the TBS.
How this argument is treated by the learned single judge?
No counterfeit.
It's a question of law. One 1988. Cut-off date.
88.
Death should be after 1988.
Exactly.
Only then family pension.
Exactly.
Prior to that, the family pension is entitled.
Huh?
That is also in the rule.
Show that.
Which one?
15D.
15D.
The rule.
Read.
Where in case of a decree holders.
Decree holder.
Decree holders. His father has approached this honorable court in 1980, and on the honorable court.
Read that rule.
I don't know. In case of a decree holder, a pension at or above, that is 15D, rule 15D, small b.
15?
D, small b.
You read B, where it is written on or after 1988, then comes D. However,
Now,
But you are not a decree holder.
that is B. I have a decree. My father was a decree holder.
Decree holder of what?
Judgment of this honorable court. The honorable court has declared him as a government school teacher, primary school teacher, instead of a TPS. They have approached this honorable court, and that is reflected in the judgment, paragraph 7. And the government advocate.
Listen to us. Your entitlement to pension is one thing. The family pension is payable to the widow generally.
Mother has expired prior to retirement.
This is an unmarried daughter.
Unmarried daughter.
The present petitioner is the unmarried daughter of the deceased.
She is also covered under the family pension.
Well,
Which is that rule? Read.
that is rule 56C.
Read. Give that book our book. You take our book, but leave it outside your mat in over.
I may pardon. Well, here, Accountant General is a party. I am appealing for the Accountant General. But no notice has been served on Accountant General. But here, that is unmarried daughter pension. Unmarried daughter pension means that is scheme introduced on 2011. That is introduced in 23rd/7/2011. The scheme unmarried daughter, disability, and widow and a divorced daughter pension.
23rd/7.
My lord, divorced daughter, unmarried daughter.
In notification 32745.
My lord, 23rd/7/2011.
11.
On the basis of that, now the appellant claim for family pension of unmarried daughter. Now here question is that the contemplated the
widow, divorced daughter.
My lord, on 23rd/7/2011.
11, yes.
Government introduced the scheme first time. It was implemented on 23rd/7/11, and your lordship come to 56(5)(e) of the pension rule, OCS pension rule.
No, you were reading this notification, no?
My lord, the notification.
Under that notification,
My lord.
The family pension is payable to unmarried daughter or not?
My lord, yes, that is unmarried daughter. But cut-off date is 2011. That is a prospective. Introduced in 2011.
Earlier it was not.
Earlier it was not there.
The first time it came, the daughters are
2011.
from 2011.
Now, what is meant by prospective?
That is prospective. Here, question is that the pensioner died in the much prior to 2011.
Whether such a death is not included or not.
That is not clear in the notification.
Then we will vote in favor of them. Whenever there is no clarity, apex court said the benefit of doubt or vagueness should go to the concerned person, claimant.
2011 is the first time introduced in this scheme.
Correct. Means what? It is introduced with effect from 23/7/2011. Means what? What is meant by that?
It is
what is the follow?
It will prospective.
Means what? Prospective means what?
Effective from 23/7/2011 from onwards.
No, we are asking you there the effect of that date
what is the effect fallout of that date? You mean to say whether the person who died before that,
Prior to 2011.
that
That is my interpretation. The Lordship may decide. That is.
That is notification doesn't say. That doesn't say.
These are all social welfare schemes.
A welfare scheme.
Very daughter should not jump into the river. With that intent, these provisions are made. Unless it says, if the pensioner dies before 23/7/2011, the unmarried daughters are not entitled to pension, then we can understand that argument.
That
But
is
how
not-
is
that is
the
not
classification of unmarried daughter based upon the fortuitous event of death of the pensioner?
He is continuing unmarried, always continuing unmarried.
She continues to be unmarried only.
Unmarried, physical handicap.
Another point is that divorce and
Don't want a dog.
Definitely.
The Lordship can see the rule 56(5).
56(5).
5D.
Similar matter also before this on another.
One matter has been decided in respect of physical handicap.
In previous matter.
A similar matter that is
Decided by the Honorable Chief Justice and
Yes, sir. Then what remains? Give one copy to Mr. Manti also.
and they have implemented the order.
that has been implemented.
The writ appeal was dismissed. In another matter, WPC number 1300-241, they have implemented the order in the case of Pushpalata Soren, which was cited there. They have not filed opinion with that.
Similar, no, he was also entered for 1966, April when.
Here I am declared as a government teacher. My father was declared as a government teacher. And the order.
Yes, sir. What do you say, Mr. Manti?
I have seen it right now.
Right.
In para 4.
Well, 4 I have read already. Para 4 coupled with para 5.
Para 5.
6. And it is already implemented, he says.
That judgment is already implemented.
And you have said we have not put that order in challenge at all.
Para 5, it was categorically stated that Pushpalata Sading was never put to challenge.
Yes.
Then that becomes the law.
That order was implemented. That is why not challenged.
After filing of the contempt petition, that has been implemented.
But they have kept open the questions. The bench has kept open that question.
Real question.
Legal questions is left open to
Whether or not the doctor of
in appropriate case if situation so warrants.
Your father was in the lifetime, he was a government primary school teacher, and the judgment of this Honorable Court was implemented, and after death he becomes TBS. This is the logic.
No, read para 7 of the judgment.
We make it clear.
We make it clear that we have not gone into the correctness of the legal issue on the point as whether an unmarried daughter of a primary school teacher covered under triple benefit scheme shall be entitled to family pension or not. The said legal question is left open to be addressed in appropriate case if situation so warrants. Here, my lord, I am not covered under TBS. I am a government teacher. My father was a government teacher. That is the judgment in OJC number 186/80, my lord. And the order was that OJC number was implemented by the authority in 85. And my father was expired in 88. Treating me as a company.
He died in.
That is the Annex 8. Annex 8 of the writ.
88.
But
Annex 8 of the writ petition. In reason
that was on 27/7/88.
well,
27.
and that the rule says that family pension at the rate of 300 plus a TI with effect from 1988.
Panel counsel for the AG office, you are not assisting us.
My lord,
You are not assisting us.
my lord, notice has not been issued to Accountant General. My learned friend intimated me, that's why I am coming before your lordship.
We will call this matter on 8th of week. We have to assist. It will have far-reaching consequence for the state.
My lord, here he is entitled, your lordship passed the order on the basis of the earlier judgment. 2 judgment has already been implemented.
Is not understand. Sir, let him appear in person, my lord, in
The
court.
question of entitlement is kept open
For a
by
second.
the bench of Honorable Chief Justice.
That has been implemented.
Appropriate case, it will be considered.
My lord,
Therefore, it needs a little deliberation.
my lord, I will.
Open with the division bench, coordinate bench.
Well, let matter be taken up any other day, I will present before it.
And you are not telling what is meant by prospective.
It is the prospective, your lordship.
Prospective has 100 and odd meanings. You see GP Singh on interpretation of statutes. The prospective is not like mantra.
That is not mentioned. That is not mentioned. That's why lordship is that is that
No, the declared rate of issue rate of
consideration, brother.
Who replaced it?
double PC number.
Notice has to go.
Judgment Annex
It has come for admission or hearing now.
the final disposal.
Final disposal.
After notice.
After notice. Yes. This matter is posted today. Post notice. Come up for hearing. First up, learned AG Mr. Murthy made some submission. And so also, learned panel counsel appearing for the AG office. First up, they have placed on board a copy of the order dated 5/11/2024 handed by the bench headed by Honorable the Chief Justice in writ appeal number 1234 of 2024, wherein para 7 reads as first off, in view of that matter needs first off, the learned panel counsel drew our attention to the state government notification dated 23/7/2011, which provides for payment of family pension inter alia to unmarried daughter, like the one in this case. First off, he says that the said notification is prospective in operation. First off, however, he did not elaborate as to what is meant by prospective operation and with respect to what it is prospective. First off, matter requires a deeper consideration and therefore post this case on 13/7 for final disposal.
13/7.
Your lordship may directed to serve a copy of the writ application.
They have been added as a OP number 2 respondent, my lord.
Who?
Let them serve a copy, my lord.
Yeah.
I will serve the copy.
You serve Monty to serve a copy of the appeal papers on the learned panel counsel appearing for the AG office. Matter requires a little.
Because 7 expands the and it needs to be explored.
Question is kept open by the bench of Honorable Chief Justice. Therefore, we have to decide that question.
Yes.
One question.
You decide that matter. We need copy. Keep that copy with us. One copy. Do you have another copy?
Oh, yes.